Head into the unknown, down the rabbit hole, where it stops no one knows. We're going head into the unknown. Na, 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 na.
Hello, everybody. Happy Monday. Gosh, I can't believe we're already almost in December. This is just crazy. So I was waiting patiently while I was, reviewing things that had happened at the groundswell this morning. And I was waiting patiently to see if Goal was going to put her response in. But we have not seen that yet. What we actually have seen is the Attorney General of Indiana, Todd Rokita, I believe is how you say his name. And he has put in a response, because not all the documents or anybody who wanted to add to this filing had to have it in by today as well. And today was also the deadline for the transcripts, but we already got those. So that's neither here nor there. So let me say hi to you guys real quick, and then we'll take a look at this document. I've only skimmed it. I have not read the whole thing yet. But it is, from what I can tell, it's interesting. So let me say hi to everybody. Hi, Grace. What's up, Carol Claus? Hi, Ava. Python Chick. Hi, Hybrid Pisces. Hi, Diana. Sold his soul to the devil. Hi, Nancy. Hey, Kimberly. Hi, Autumn. Search and Rescue Canine Mom. Hi, honey. Hey, Joni. Hi, Heather Bratt. So what now? More filings to come from Alan then? No, there seems to be a little bit of confusion that I think people think that this is the response on behalf of Goal, but it's not what I read. So when we read through it, we'll figure it all out. Hi, Teresa. Hi, Polly. Hey, Shaz. I rescue all the dogs. Hey, Malia's mom. Hi, Missing Unsolved Crime. Hey, Sarah. Joni, I think I said hi to you, but now I'm going to forget, so I'm just going to end up saying hi to you guys again. So whatever, just take it twice or 3 times, whatever works. Hi, Ava. Hi, Rexy. BG. I don't even know how you survive on these streets, BG, with that name. We got a BG and a BH, and I'm like, man, I'm surprised you guys just aren't under attack on these Delphi streets. Hi, Teresa. Hi, Natasha. Hey, Azulian. Hi, Mother of Dragons. What's up, Chelsea? Hi, Aaron. Let me see. I probably missed a whole bunch that just popped in. What's up, Johnny? Inspector Gadget. Oh, do you? I didn't test. Maybe I should have tested, but I didn't test. I feel better. I'm still congested, but I feel better. I actually feel better. So we're headed in the right direction. Kelly, Kelly. Hey, the Rockaways. Hey, Lilith. Hi, Starlight Ann. Hey, Sean. 1960. What do I do to keep my teeth so white? I don't. I just have white teeth. I don't know. I don't know how I do either, because I smoked for like a long time. And I drink coffee. I don't know. Python Chick's birthday's tomorrow. Woo! Hey, Suzanne. Hi, Southern Sweetie. Hi, Dina. Hey, Brutally Honest. I just saw you up there. I must have missed. Hi, Boy Mom. Hi, Mandy. I missed like a whole little section in here. Well, hi, anybody who I didn't say hi to. Hello, hello. Hey, Jen. Momo Shark. YouTube is so screwed up. When I clicked on your live, it already had 1.5K likes, and there was no chat box, so I couldn't chat. I had to restart the app. It was so weird. That's fine. Let's get it to 1.5K likes. We could do it. Oh, thank you so much. And from down under. Thank you from down under. I appreciate it. Been noticing you saying his name right. Good on you. You're so, thanks, Lauren. I'm trying not to miss anybody. So if I didn't say hi to you, I apologize. All right. So from what I'm seeing, this is more just him. Well, it's not. He doesn't even do it. It's like the deputy attorney general who does it on his behalf. So this is just him putting his 2 cents in. So her attorneys still have to respond, because if you guys remember, the attorney general actually would not represent her. They chose not to represent her. They never stated why, but they just said they weren't going to. Now it says 3.4 thousand. Sweet. Hi, Kate. Hey, are any pants on fire yet? They should be, but then most of Indiana law enforcement would probably be gone. But that's just my opinion. Hey, Lambert. Yeah. Did I cover my mouth? Let's just have it then. I don't want to. Yeah. Well, it spreads so easily. You just never know. Okay. So this is the attorney general. Let me just see who actually signed off on it, because I think it was Angela. It's the chief counsel of appeals, Angela Sanchez. There's the counsel for the amici, the counsel for the relator, the counsel for the respondent. This is just his office. Yeah, so it's Angela Sanchez, the chief counsel of appeals for the Indiana Attorney General's office. So she just filed this on behalf of Todd. All right, let me pull it up for you guys so we can start going through it. I skimmed it. It very much sounds, from just what I skimmed, like I said, we're going to read it together. But what I skimmed, it sounds very much like her attorney's response to the other writ, just like timing wise, but we'll see. What'd you say? Letters to Christopher? No, not the new one. I know that she's got a new book out. I'm not buying that shit. I already have 2 pieces of garbage. I won't buy another. Yeah, she won't file. I don't think we'll get hers until a little bit later, but we'll go live when we have hers too. But there's no way I can. I knew, I was like, oh, what do I do? Do I go live, or do I just wait until we get hers and read both? And I was like, there's no way I'm going to be able to read both. I would struggle. All right. And you guys would be so proud of me. So I spent a couple days and I actually went through and I labeled like all my PDFs. I know it was quite a bit of work, but I did it because I was so frustrated with myself from Friday and not being able to find that. But then I realized, even though they're labeled, I still might not be able to find shit, but it is what it is. Hey, Sharon. All right, we can just double check and see if there's anything else that's been filed yet, but I don't think there has. I'm sure she'll do it at the last hour she possibly can, or the attorneys will. No, that's still the last one. Should we check out the other case, though, and just see? This one's still pending, active. Nothing new on that at all. Okay. Let me come back over. Hi, Crime Curious. Hey, Melissa. Nope, she has not filed yet. Hey, Mace Mama. We haven't started yet, so we're just getting ready to read through it. But nothing from the judge yet, just from the attorney general. So they're just adding their 2 cents before the cutoff time, which is at end of court today. Hey, Wayek. What's shaking? Polygraph. I like it. Read it in a salty voice. Okay, I'll do my best. I'll do my best. Okay, so it's just, the original at this, they're just responding. So it's the state of Indiana, the relator versus Carroll County. She's the respondent. This is the Indiana Attorney General's response to the relator, Richard Allen's petition for a writ of mandamus. Go through the table of contents, dun dun dun, and then here's all the case citations, all the case precedent that we talk about a lot, that they have to put in here to show that there's already case precedent saying this is what we have to do. This is what needs to be done. And they put a lot in there. Other authorities, they added in some court rulings, some original action rules, professional conduct rules. And here we go. Okay, I'm going to turn my camera off. Yeah, you haven't missed anything. Yeah, absolutely. That's what I think too. I'll read it low sodium. I'll be like, well, I'm not going to read the background that way, but maybe I'll read the actual responses. Ruckus just said they ruled against it. Who did? Who ruled against what? High cop never sucks. Hi, on the case with Jeannie. Hi, Angie, baby. What's up, Thistle? Ruckus just said they ruled against what? I don't have any rulings from the Supreme Court yet. The Attorney General doesn't get to make that ruling. This is not an order. And anything that you see that is like this is like, essentially you can consider it like motions being filed on behalf of one party or another. I may be confused because the Attorney General is not taking, like I said, I've only skimmed it, but it's the Attorney General is definitely taking Gull's side. No, yeah, this is not a Supreme Court order. There is nothing, and the Attorney General doesn't get to make the ruling. No, so yeah, no, the Attorney General doesn't get to make the ruling. The Supreme Court does, and so when you have, you'll have an order of the writ, or how do they word it? Let me see if I can see exactly how they word it. But it'll say order, like order granting, order denying. You know what? Do I have one right here? Let me see if I have one. This is what a Supreme Court order looks like. This is what we're wanting for both writs. More importantly, the second writ. We want one that says, like, the Indiana Supreme Court, here is the Supreme Court's order. This is what you actually need. But let's be very clear. Today is the 27th. It is the deadline for her to put her response in, or anybody who needed to add a response to it. Today is not the day we're getting a ruling or an order on anything for the second writ. Could we get an order on the first writ? Yes, whenever they decide to do it. The first writ is anybody who wanted to add anything to it, that's done. And it's now pending, and it's waiting for the Supreme Court to make their decision. The second writ, which is what we're talking about today, I know it gets very confusing because there's a lot of different pieces and parts moving around, but this will be when the order comes is that's what the ruling is. That's what the Supreme Court rules. That's the end all be all and things. That's it. So we don't have that. That's just an example I was showing you. So what you're seeing here is just a filing. Well, and I keep hearing this about Skinner, Georgia, and I keep looking for any source that can prove it to me, because I have heard it a lot. I've also heard that he called. When Richard Allen called, they said to him to go to the grocery store and put in his statement or his, whatever. I have no documentation that I can prove any of that. If you guys do, please give it to me. I'd love to be able to use it and see it. I do keep hearing that he originally talked to Skinner, who's now passed away, and that's why they're not using him. I don't have any source. I need something. I need a source. So no, this is definitely not an order by the Supreme Court. So unless there's something else out, and like I said, I just looked on both cases, we won't have an order for this today for the second writ, which is what the Attorney General just commented in. And the first writ, I'll go double check again, but there was no order. But I'll just look just one more time before we get into this, but the Attorney General doesn't get to make the decision. So no, this is not it. Yeah, this is just the Attorney General. Well, I shouldn't say just the Attorney General, but I mean there is something to be said about the fact that the Attorney General's office denied to represent her. So it's interesting that they're taking this stance. Okay. I just showed you guys all that, didn't I? Let me go back to where I was. Okay, let me turn this off and take a drink. Okay. Do you think that's why the Rockaways? Hey, Artemis Prime. Hey, Ginger Snaps. I'm just, you know what? It wasn't even about the amount of people. It was about the purpose. And I'm still very proud of everybody that showed up there. And I know that because there wasn't a mass quantity, you can't predict that. You can't predict how many people will be there. And as soon as you try to, it'll be the exact opposite. You know that. That's like a birthday party. I mean, the AG was reprimanded by the Supreme Court of Indiana recently, and he sued a doctor providing abortion and lied about whether she reported SA. So he's not too good of a source for anything. Hi, Kaleido. What's up, Melissa? Oh, that's a tough one. That's a tough day. Well, that's true, too. It was super cold, but we did have a good day. Nancy was there at the protest, or the peaceful protest. Unresolved crimes uncovered, stated the first interview was with Skinner. Does she say it in one of her videos, Lambert? I'm going to have to go look. I was binge watching some, but I don't remember that. And she would source something like that, I would think. So I'll go double check there. Because I have heard it a lot. I don't have a source to prove it to you guys. All right, you guys ready? Indiana Attorney General Todd Rokita, pursuant to Rule 3F of the Indiana Rules of Procedure for Original Actions, files his response to Allen's verified petition for writ of mandamus or prohibition. The background: in 2017, 2 teen girls were murdered near the Monon High Trail in Delphi, Indiana. Richard Allen was charged with the murders on October 28, 2020. On November 14, 2022, Special Judge Francis Gohl appointed Brad Rosie and Andrew Baldwin to represent Allen. In October 2023, discovery subject to a protective order was leaked to the public. On October 12, 2023, Attorney Rosie wrote to the court acknowledging that the defense team was the source of the leak and arguing that disqualification of attorneys Rosie and Baldwin was not the appropriate remedy. Judge Gohl set a hearing for October 19, 2023 to discuss the upcoming hearing on October 31st, 2023 and other matters which have arisen. Baldwin retained an attorney for the hearing, and that attorney filed a memorandum regarding possible disqualification or sanctions. At a chambers meeting before the hearing, Judge Gohl informed Baldwin and Rosie of her concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Judge Gohl outlined her concerns as improper comments to the public after stating they would not talk about the case. Baldwin and Rosie issued a press release that was potentially violative of the ethics rules. Violative of the ethics rules. I don't think it was. Conflict of interest. Rosie filed a tort claim on Allen's behalf against the DOC. This is what they're saying that Judge Gohl stated, which is what she stated. But I still have arguments. Protective order violation, Baldwin negligently released discovery to Brandon Woodhouse, who disseminated it to the public. Baldwin did not alert the court or the state to the release. Filing motions with inaccuracies and falsehoods. The pleadings regarding safekeeping Allen and the DOC contained proven false information. Protective order violation, Baldwin was the source of more leaked discovery, which spawned a criminal investigation and may have resulted in a suicide. Judge Gold found that Baldwin and Rosie had demonstrated gross negligence and incompetence in representing Allen. Judge Gold stated that she did not want to say this in open court, but would if she had to. Judge Gold confirmed that if Baldwin and Rosie did not withdraw, she would remove them. After consultation with Allen, Baldwin and Rosie chose to withdraw. When withdrawing their appearances, Baldwin and Rosie claimed it was unfair because they were forced between being accused of misconduct in open court or withdrawing. In open court, without Baldwin and Rosie present, Judge Gold announced that they had withdrawn. Rosie tendered 2 documents on October 25th, 2023, and noticed that he was still Allen's attorney and a motion to disqualify Judge Gold. Judge Gold took no action on these filings because Rosie was no longer counsel of record. On October 27, 2023, Baldwin's attorney, David Hennessy, filed a motion to reconsider, claiming that there had been no valid motions to withdraw by appointed counsel. On October 27, 2023, Judge Gold appointed 2 new attorneys to represent Allen. At a hearing on October 31st, they're missing something here that, she took no action on these filings. That's an inaccurate statement because she did take action. She ordered her court clerk to remove them, but, at a hearing on October 31st, 2023, Baldwin and Rosie were present, having tendered appearances the day before. Hennessy also appeared for Baldwin. Baldwin or Rosie did not attempt to present evidence to rebut Judge Gold's factual findings, finding that nothing had altered the court's concerns about counsel's gross negligence. Judge Gold disqualified Baldwin and Rosie from representing Allen. Hennessy withdrew his appearance that day. No attempt was made to appeal Judge Gold's order. On November 6th of 2023, attorneys Kara Winicki and Mark Lehman filed a petition for a writ of mandamus with the court asking the court to order the trial court to reinstate attorneys Baldwin and Rosie, to order the trial held within 70 days of the granting of the writ, and to remove Judge Gold. All right, let me look at the footnote. Amicus Indiana Public Defender's Counsel agrees that the procedure for selecting successor counsel was improper, but this claim is not raised by Allen and is unavailable for review. Okay. Hi, everybody that just popped in. So this is the argument now. An original action is a limited remedy governed by strict procedural rules. Original actions are viewed with disfavor and may not be used as substitutes for appeals. That's why I told you guys, this is a lot of the same argument that her attorneys actually did put down. Give me 1 second. Sorry, I just had to take a drink. Okay. Yeah, they're using a lot of the same arguments. So they're trying to say that instead of these other attorneys coming in, like Baldwin and Rosie, should have filed, with the appellate court, stating that they disagreed with, what Judge Gold had done. That's so honestly above my head on the legal side of things. I don't see why, because there's no reason that they can't go this route. And if you listen to what like Kara was saying, this is actually the most reasonable route to go, because there's nothing with the appellate court that can like change what's happening right now, like the Supreme Court can, in her response to the respondent's response, the one that was really, the name was really confusing. And I just don't agree with some of the things that she said. But that's, once again, we'll keep going, because my opinion right this second isn't what's important. Before a writ will be entertained, the relator must raise the question by written motion to the trial court, original action. If remedy by way of appeal is full and adequate, a party may not invoke the jurisdiction of the court under the original action rules. A writ of mandamus will not issue unless the relator has a clear and unquestioned right to relief and the respondents have failed to perform a clear, absolute, and imperative duty imposed by law. These are all cited, so I'm not reading you guys all the citations, but if you guys can check out any of these if that's something that you're interested in. I'm just not going to read you all the numbers. Hey, Coach Kev, good to see you. Hi, Mandy. I know this is asinine by the AGs, literally endorsing not following established judicial procedure. Well, that's probably why he gets reprimanded. I'd make a great 911 dispatcher. Probably not right now. Half my voice is gone, and I can't stop coughing. So, 1, the request that the court reinstate Baldwin and Rosie as Allen's court-appointed as attorneys is inappropriate for a writ. A writ of mandamus reinstating Allen's former attorneys is not presently warranted. The conditions precedent for a writ are not satisfied as the claim was not clearly presented to the trial court and a remedy by appeal is adequate. Not according to Kara, it's not. So even were the court to review the merits of Allen's request, the record is not sufficiently developed for the court to resolve the question. Let me check the footnote. Allen includes materials exhibits L, U, V in the record of proceedings that were not filed, tendered for filing, or entered to the respondent court. This court should strike or disregard these exhibits. Striking material on appeal that was not part of the record in the trial court. What were L, U, and V? The record of proceedings that were not filed, tendered for filing, or entered in the respondent's court. I'm wondering if that's Rosie's filings. We'd have to go back and look. Appeal is both adequate and preferred to review whether a trial court abused its discretion in removing counsel. But the problem is that would not happen until later. That's not going to happen until after everything is done. So that's not going to work. Ariel, you looked it up? Okay. Yeah, this was to the second writ. This is the Attorney General's response to the second writ. This isn't Judge Gold's response. We're still waiting for that. Kara is Carrie is the Kara is the attorney that filed the writ. She's actually the one attorney that filed both, was part of both writ 1 and writ 2. Allen did not seek interlocutory appeal of either the trial court's order granting withdrawal of counsel or its subsequent order declining to allow counsel to appear pro bono. The record does not indicate that Allen asked his newly appointed counsel to appeal, nor does relator explain why original action counsel could not file a limited appearance to seek certification of the court's order, as counsel did to file motions in preparation of this action. Not true. They were filing things and she was removing them. So that's why they couldn't file anything. So I did ask about this interlocutory appeal because I thought that would be the route they would go. But the writ of mandamus cannot be used as a substitute for appeal. This decision could have been appealed. Disqualification of counsel can be required, or it can be at the discretion of the trial court. The extraordinary remedy of a writ is not available where the matter is within the discretion of the trial court. An action for mandate cannot be employed to adjudicate and establish a right or to define and impose a duty. Though this court has reviewed a disqualification of counsel through original actions, the court has not issued a writ to reverse a trial court's discretionary removal of counsel, but has issued writs where counsel's continued representation exceeded statutory authority. Granting writ to disqualify special prosecutor. most of their stuff is citing literally other case law. Granting writ to remove private counsel retained for state agency in violation of statute. Denying a writ to reinstate disqualified attorneys where attorneys requested to withdraw if granted a certain motion. So this is all hearings that this court, the Supreme Court, has determined the removal of counsel. Denying a writ to reinstate, we read that. But appellate courts have reviewed discretionary removal of counsel, that's the important part, through an interlocutory appeal. Reviewing disqualification of counsel for a conflict of interest. Let me see what Ariel came up with. That's a great question. So I was looking at that when this all very first happened, but it was before the writ was even filed. So I'm curious. I didn't continue to go down that avenue because they ended up filing the writ instead. So the removal here was at the discretion of the trial court. So mandamus is inappropriate. I cannot imagine that Kara is not going to want to respond to this. Okay, so B. Allen does not identify an absolute duty to reject counsel's withdrawal or to permit them to reinitiate representation. The law does not place an absolute duty upon courts not to interfere with the attorney-client relationship, but it bars arbitrary and unjustified interference. Allen contends that respondent acted to terminate the attorney-client relationship when she had an absolute duty to refrain from doing so. But Allen does not identify the origin of this absolute duty. Allen's brief does not contain the verbatim statement of, quote unquote, the relevant parts of all cases, statutes, and other authorities relied upon, required by the rules. It's such a, I'm going to be very, it's such a pissing match between attorneys. That's what we're really reading through right now. It's like a little cat fight. No, I shouldn't say little, because I mean, ultimately in the end, it's going to be huge, because whatever happens here could set a lot of case precedent for the future. But what we're reading back and forth when we go through these all the time is like, it's like a pissing contest. It's like, well, you didn't put the rule in there. Well, no, you didn't put the rule in there, and you didn't do that. But Allen does not identify the origin of this absolute duty. Allen's brief does not contain the verbatim statement of the relevant parts of all cases, statutes, and other authorities relied upon, required by the rules. Such a statement is necessary to define the source and scope of the duty that Allen seeks to mandate. A trial court's authority to remove counsel is more nuanced and less absolute than Allen suggests. Okay, so one, the right to choose counsel or continue representation is not absolute. The Sixth Amendment guarantees every defendant the assistance of counsel. Those who do not need counsel appointed also have the constitutional right to choose counsel. But indigent defendants do not have the right to choose appointed counsel. Okay, I'm going to continue reading before I put my 2 cents in here. The United States Supreme Court has not recognized for appointed or retained counsel a distinct right to continuity of representation. And the court has rejected a constitutional right to a meaningful relationship with counsel. But the Sixth Amendment's purpose of ensuring a fair trial imposes a baseline requirement of competence on whatever lawyer is chosen or appointed. So this is very convoluted, and they're trying to streamline it, which I see what they're doing. So you don't have a right. Okay, so you're arrested, you go in, you say, I'm going to hire my own attorneys. You have the right to whatever counsel you want. Now, if you go in and you say, nope, I'm indigent, I can't afford it, I need you guys to appoint it for me, that means that the court has to appoint you attorneys. You don't get to choose them, like right off the bat. But I will tell you that there are plenty of case examples that could be used to show a client and their attorney's relationship. And if it's not working, you know, we'll throw Sarah Boone out here, for example. She's on attorney, you know, not pro bono. My gosh, why can't I think? Her public defender, she's on her 7th one because they can't seem to get on the same page. Like literally the last one was like she should just represent herself because nobody's going to do it to her satisfaction, essentially. So this is a big difference, though, because he didn't have the right to choose his attorneys, right? So he was given 2 attorneys. He was given Baldwin and he was given Rosie. Now there's a big difference from him being able to choose those attorneys when he very first said, hey, I'm indigent and I can't afford my own, to a year down the road where they have already come up with a defense strategy. There is no conflict. There's no conflict of interest between them. And then, not to mention, they come in and decide that they're going to go, hey, we're going to be here pro bono. This is why this is such an extraordinary thing that we're witnessing, because this is not normal. This is not something that you're going to see when you follow court proceedings or even appellate stuff. Like, this is very outside the box. So I think it makes it very interesting if you like the legal side of things. So they can't just go, hey, sorry, your Sixth Amendment, we have the right to give you whatever counsel we want to. A year later. Yes, that is the case at the beginning, but not necessarily a year later. Now, he's also saying, or the attorney for the Attorney General is saying, sorry, give me 1 second. You guys have to cough. Okay, so the attorney for the Attorney General is essentially saying here, like, you don't have the right to say that you get to be his attorney still because of his Sixth Amendment. But they're backdating that for, to when he would have actually been appointed those. It's not the same thing. Once they form the relationships, and then the attorney for the Attorney General is essentially stating that sorry, my husband walked in and kind of threw me off my whole rhythm. I'm going to reread this real quick so I can get back onto you and tell you what I was thinking. Okay, so they're saying that that Kara, who filed the writ, didn't put in the rules that show once you have a relationship with that client, and once you already come up with the defense strategy, she didn't put the rules in. Now I'd have to go back and I obviously can't remember every one of these documents. I'd have to go back and see what she did or didn't do. I'd be surprised that she didn't actually cite something that shows that. But they can't just go ahead and say, hey, sorry, you're out because of, we have the right to say who your attorneys are. That's not really it. Now, Gold just filed something. All right, let me go check. I'm not going to read it till I'm done with this, though. Let me go see if I can pull it up real quick while I'm in between thoughts, because that'll be the best way. Otherwise, I'll lose what I was thinking. Yeah, it's there. Okay. We'll look at that when we're done then. I see it there, but it's not clickable yet. I hope that the Supreme Court grants these. Otherwise, judges will be violating defendants' rights and not even worry about it because they can appeal, trying to tell that someone convicted in prison for years and years. Yeah, I took it as Rosie couldn't represent Alan in both, but I understand 10% of this. I don't know of any type of conflict that says that they can't represent somebody in both. Maybe not while they're going on at the same time, but the tort that she's referring to is simply just it's like a placeholder saying at some point he's reserving, Richard Allen, who is their client, is reserving his right to sue. That's all. I mean, it's because there's going to be a statute there, so he's putting it in place, just saying, hey, this is what, what's going to happen later. It doesn't even necessarily mean that Rosie would be the one to represent him when that time comes. It's just the tort. It's like the placeholder saying, hey, we're doing this. But does it with every, Kathleen Zellner does it with every client. Okay, let's keep going. I don't, oh, did Lynn pop in? Hi, Lynn. I think that's open for interpretation, which is where my whole problem with this falls. So Lynn was saying, let me see if I can find it. They breached their contract with attorney-client privilege. Well, that's why I feel like it's so up in the air, and there needed to be more clarification. And I think the biggest issue with this was that she didn't just tell them, hey, come to court on the 19th, be prepared to argue your case against why I shouldn't disqualify you. There shouldn't have been anything happening behind closed doors. It should have just been, bring your people, bring your witnesses, bring your documents. We're going to air it all out, and we're going to figure out what happens here. And then she disqualifies them. She disqualifies them. Then they can go on. It's all the weird innuendos and the fact that they weren't really sure what was happening. There really should have been no question what was happening. Now, could they have assumed? Yes, but you can't assume in a legal situation. You have to know. It literally should be assigned. That hearing should have been assigned to be a disqualification hearing for them. And everybody bring in their people, and everybody bring in their witness, their documents, and so on. It's so clouded in that gray area that it causes issues. And she, as the judge, is responsible for that. Whether she thinks she was right or wrong or whatever, she's responsible for that gray area. So now she's responsible for the public having an issue with the transparency of the Indiana courts. And that's also her responsibility. It should have played out very differently. But now, hindsight's always 20/20. I could come in and try to be a Monday morning quarterback or whatever they call it. But she screwed that up. Does that mean that they weren't wrong? I'm not saying that. I don't think that we can tell whether they were wrong, because nobody was able to present the evidence necessary for us to know one way or the other. But that's my opinion. Take it or leave it. I'm fine with it. You guys all know you guys can have whatever opinion you want to, as long as you're nice to me and everybody else in this chat, at least. Okay, so let me get back to where we were. For appointed retained counsel, a distinct right to continuity of representation, and the court has rejected a constitutional right to meaningful relationship with counsel. But the Sixth Amendment's purpose of ensuring a fair trial imposes a baseline requirement of competence on whatever lawyer is chosen or appointed. This is true, but she didn't determine that they were incompetent in the hearing. She chose to do it in chambers. That kind of just leads back to everything I just said. There's too much gray around that, and whether she violated their rights to due process. Just because they're the attorneys doesn't mean they don't have their own constitutional rights. Can't you read between the lines? You're an attorney. That's what you're supposed to do. I've never heard that, by the way. I've never heard that was like part of the job requirement for being an attorney, was to read between the lines. So the right to choose counsel is not absolute. While the right to select and be represented by one's preferred attorney is comprehended by the Sixth Amendment, the essential aim of the amendment is to guarantee an effective advocate for each criminal defendant, rather than to ensure that a defendant will inexorably be represented by the lawyer whom he prefers. But for retained counsel, courts must recognize a presumption in favor of the defendant's counsel of choice. So this is where the next tricky comes in, because then they come in and then they file that they're pro bono. So now they are his counsel of choice. So where does that, she did not have a finding of gross negligence or incompetence, because they withdrew. So there was no finding of any of those things. So even if you go with, they walked in and they would, like, any argument you can come up with, there's a counter argument that's so easy because it was so screwed up. So they walked in, they withdrew, that's it. Too bad. Okay, great. So now you're going to say they withdrew. that means you as the judge did not find them grossly negligent or grossly incompetent or any of those things because they withdrew. So you can't have both. So now they're coming in pro bono. So they withdraw. Here's our withdrawal. We verbally withdraw. We say we're going to withdraw. Okay, perfect. Everybody's like, they quit. That's on them. Perfect. Okay, now they didn't quit. They came in and decided to work pro bono. So now you don't have any of the gross negligence stuff anymore because it never happened. So then she just says, well, too bad. I found you guys grossly negligent. That's just how it is. But you didn't find us grossly negligent because we just withdrew. Hold on, you guys. Sorry. Hey, True Crime Obsessed. Give me 1 second. I'll put it on there. Christine. P.S. T has an actual degree in criminal justice, so she has a very informed opinion. I've just never practiced law, so I'm just reading the papers here. Come on, Christine. It's just convoluted. Let me see if I can grab you a link real quick. True Crime Obsessed. I should have it pretty accessible. I think maybe. You know how I am with like links. Not the bestest. In case you guys want to read along. Let's see if this works. Tell me if that works. If that doesn't work, then I love Bluey. If that doesn't work, then I'll try to figure something else out. Okay, so Indiana has not addressed whether the distinction between retained and appointed counsel alters a court's authority to substitute counsel. And authority is mixed in other jurisdictions. The Colorado Supreme Court recently held that indigent defendants have no constitutional right to continued representation by appointed counsel. The court found that any right to continuity of counsel must flow from the right to choose counsel, which indigent defendants lack. But the court recognized that indigent defendants have an interest in continued representation by appointed counsel if they can demonstrate that prejudice would result from substitution with a different court-appointed attorney. Yeah, that's a big deal. Trial courts must give great weight to a defendant's preference. Whether requiring a presumption or weighty consideration, trial courts must weigh a defendant's preference for representation against the circumstances favoring disqualification. Okay, so whether requiring a presumption or weighty consideration, trial courts must weigh a defendant's preference for representation against the circumstances favoring disqualification. Okay, so essentially what they're saying is that Indiana does not actually have a distinction about this, even though Colorado just recently did hold one, which would also make this more groundbreaking because of whatever decision this Supreme Court of Indiana makes will end up in future filings. So the right to counsel must be balanced with the need for a fair trial. Contrary to Allen's claims, more than two circumstances may require a court to interfere with the defendant's preference for counsel. As Allen recognizes, a defendant cannot insist upon counsel who is not admitted to practice. Okay, great. And a court may act to remove counsel when the representation creates actual or serious potential for a conflict of interest, including refusing to permit the defendant to waive the conflict. But these are not the only circumstances that allow interference. I think everybody's on the same board with that, on the same page, that those are the main two reasons that anybody should be disqualified from representing anybody, is that if there is a conflict of interest or somebody who doesn't actually belong to the bar in that state. I think those are the two common ones that everybody really knows about. 1 second. Okay, so counsel's conduct or personal circumstances may justify removal. Gross incompetence or physical incapacity of counsel, or I don't know how to say that, contumacious conduct that cannot be cured by a citation for contempt may justify the court's removal of an attorney, even over the defendant's objection. A trial court may disqualify an attorney for a violation of the rules of professional conduct that arises from the attorney's representation before the court. And a defendant may not insist on the counsel of an attorney who has a previous or ongoing relationship with an opposing party. Well, that's a conflict. So yeah, we already know that. Even when the opposing party is the government. Oh, this is okay. So just because the two attorneys don't like each other, or so they're saying that you can't just. It doesn't have anything to do with whether you guys just have a conflict, which includes the government, which would be the judge. Holding defense counsel should be disqualified where representation violated duty of confidence to former client, the state. The need for efficient administration of justice may require removal. Finding no error in replacing preferred counsel who was indefinitely unavailable due to illness, and other rulings may deprive a defendant of his preference. While the denial of a continuance may infringe upon the defendant's right to counsel of choice, only an unreasoning and arbitrary insistence upon expeditiousness in the face of justifiable request for delay violates the right to the assistance of counsel. Okay, courts must also balance the needs of the public and the victims. The general public and the victims of crimes have an interest in the even-handed administration of justice. Yes. Trial courts have the discretion to balance these interests with the defendant's desire to be represented by his preferred counsel. Though varied interests may necessitate overriding a defendant's preference, disqualification is an extreme remedy that should only be used when a court deems it reasonably necessary to ensure the integrity of the fact-finding process, the fairness or appearance or a fairness of trial, the orderly or efficient administration of justice, or public trust or confidence in the criminal justice system. This is what we're saying. Okay, so they cleaned it up. Okay, the lack of record prevents review of counsel's disqualification. The lack of record prevents review of counsel's disqualification. Defense counsel's withdrawal truncated the proceedings, and the present record prohibits complete review of whether the trial court's concerns justified substitution of counsel. In chambers prior to the October 19th hearing, the court listed reasons it felt counsel should be disqualified that it intended to address in the hearing. The prosecutor was prepared to present evidence from the leak investigation. But this hearing did not occur because defense counsel withdrew rather than challenge the factual allegations at the time. At the October 31st hearing, where Baldwin and Rosie attempted to appear for Allen and had their own counsel, no additional evidence was offered or arguments made to rebut the court's allegations. I don't see it that way. I know that there are people that do, and I know some of you people that do are watching, and I get it. But I don't. I just don't see it that way. Especially after we read the transcripts, and even Rosie's like, so I can stay? And I'm obviously paraphrasing what he said. And she said no. She told him straight out no. It didn't matter whether they went in there. So this whole they withdrew rather than challenge the factual allegations at that time. Well, one, you're not the finder of fact. I want to make that very clear. This attorney and this attorney general, they're not the finders of fact. That's not them. This is where Richard Allen comes in and needs a jury that would be the finders of fact. That's a problem for me. But they didn't shame the girls, Lynn. Mitch Westerman did. Mark Cohen did. Robert Fortson did. Those guys, by sharing all of that and stealing the photos, If somebody comes into my house and steals something from me and goes out and uses it to commit a crime, that's not my fault that they broke into my house and stole it. That's not, I don't think that's fair. I do think that the other ones should be punished. I do. I don't think that Robert needed to do what he did, but that's a whole nother sentence. But my problem still, regardless of that, there is no, it's even, the Attorney General even says, due to the lack of record, we're prevented, anybody else is prevented from reviewing the counsel's disqualification because she didn't allow them to go out there and say, hey, this is our evidence. These are our witnesses. We're going to have to agree to disagree on that one, Lynn, because I don't agree with that. And even so, even if you wanted to say, then it would still just be Baldwin. Why did Rosie get held accountable for what Baldwin would have, quote unquote, done, or what Mitch Westerman would have done? That's where I don't, just, why not just tell them, hey, the 19th, we're holding a disqualification hearing. Bring your shit and we're going to go through it. That's what we're going to do on the 19th. And do it in open court. And have a disqualification hearing with actual evidence and facts. None of us would be sitting here if we all actually saw all the details. You know, you want to have cameras in the courtroom? Fine, have cameras in the courtroom, but be prepared because we're going to be talking about disqualifying you. I would have been fine with that still. But she didn't want them out there. She literally told Rosie, and Rosie said, if we can reschedule this and be prepared, I'd be happy to do it, essentially. At the October 31st hearing where Baldwin and Rosie attempted to appear for Allen and had their own counsel, no additional evidence was offered or arguments made to rebut the court's allegations. There didn't need to be because there's no finding of gross negligence because they withdrew. So what do they need to bring evidence for when there's no finding of gross negligence? And if there was a finding of gross negligence, then why didn't she report him to the bar doing the proper procedures that she's supposed to do to actually report them for doing something wrong? It's just so gray. It shouldn't be gray. Why do you think the discovery order 1122 was so strict on who could view it? Have you seen any cases with discovery order that confidential? Yes. And I think that has a lot to do with just the gag order in general and everything that they had done to preserve or to present that they were preserving the integrity of their investigation. I should say that because there's also people who will disagree on the other side of that. But yes, that's not uncommon, especially going into once you have the arrest and going into trial, because they don't want all that out. From the released transcripts, it appears the defenses who asked for the in-chambers meeting on the 19th. So why would they have been expected? Why would they have expected that was going to happen? Right. Well, because she didn't request it. That's a good point too, Tammy. But I don't even think that this is my observation. You guys can take it or leave it. Do what you want with it. The defense team, specifically Rosie, was confused on what was happening and what was going to happen for the hearing on the 19th. And I also think that he mentioned the 31st, but don't quote me on that. But I know he was like, well, what are we actually doing here on the 19th? And so her response was, go ahead and come in early. We'll meet in chambers and we'll discuss it. So she kind of scheduled it, but he kind of requested it because he wanted to know what they were even doing. So, I mean, once again, it's so gray. I mean, you could go on both sides of this and be like, did he request it or did she technically say that's what was happening? Because he wanted more information about what, and that tells you right there that he literally doesn't know what's going to be happening on the 19th because he's asking her for clarification about what the hearing is for. You think that Rosie asked that but knew that he was walking in the door on the 19th? to be disqualified? No. All right, let me just double check and see if hers is up yet. We're not done with this one yet, but just to take a peek. Take a gander. It is. All right, we'll throw it up here so it's ready to go. Okay, let's finish this one. Remember when I said at the beginning of this that I was going to struggle if I had to do both at the same time? Of course she drops it. That link didn't work and I can't get to it. Okay, no worries. I'm sorry, you guys. I'll try to post both of the links. If any of you guys can, then this will, let me send it to you in Messenger, and then you can link it. And then the dog is scratching at the door, of course. So this is the one we're reading now, Thistle. And then this is the one that we're going to read. So maybe you can figure out how to share that link. And Lynn, I absolutely respect that you feel that way, and I'm not saying that that's even necessarily wrong. What I am saying is that there should have been the actual procedures to show that to the court and to the public. Now, we could just have a difference of opinion on whether we think that they were gross negligence or wasn't. That's fine, but the fact is she's saying that she created a finding that she legally never created, and that's where my whole issue with this comes in. And if anybody, like, when people ask me, like, what do I think the remedy should be, I believe the remedy should be that another judge is put in to do a disqualification hearing and determine whether Baldwin and or Rosie should be disqualified from the case. That's what I want to happen, because I think that that's the proper procedure to what should happen. And then if that judge says, yeah, you guys, I'm sorry, looking at everything here in the totality of what, this evidence, you guys committed gross negligence. I'm having a finding of gross negligence with everything you've done. Then I would be more inclined to go, okay, that's just it. And with Richard Allen it's just, there's so much missing. So I think our opinions of saying, like, yes or no, they did commit gross negligence is really irrelevant. And once again, my opinion, so you guys take it and do what you want with it. But I just feel like it's irrelevant because we don't actually know. We don't have all the evidence. And I can tell you that we don't have all the evidence, because if we did, then why in the world did McClelland have a whole bunch of people there to provide evidence that never actually got presented? So we don't know everything that happened. And that's where I'm at with it. So I think that, and then I think the Supreme Court should decide whether Gull should stay or go. If the other judge decides that there was not gross negligence and that those attorneys are staying, I think that there's no choice but for Gull to go, because there's no way that there would not be a perception of prejudice of prejudice when she's making rulings. And any trial judge can handle this trial. I mean, you put a judge in place, they're just there to determine the law, right? So you can put them in place. They don't have a strategy per se. That's not their job, like the defense team. So if the defense team was allowed to stay, then Gull should go. That's what I think. But and I've said this a few times. I believe whatever happens with the Supreme Court on both of these writs, we have no choice at this time but to respect it and move on and just go, this is where we're at with the case now, and it is what it is. Okay, so respondent raised concerns that could warrant disqualification depending on the circumstances. So remember, respondent is Judge Gull. The court's concerns raised questions regarding counsel's compliance with professional ethics and ability to provide Allen effective representation. After the state sought a gag order, counsel had assured the court they did not intend to try the case in the media, but then issued a detailed press release challenging specific evidence that the court believed violated professional conduct Rule 3.6. The restriction on publicly commenting on specific evidence and related limits on pretrial publicity exists to protect the defendant's right to a fair trial and the availability of an impartial jury. I could just argue with this point so much, because there's nothing that they put in there that wasn't just defending their client being innocent as much as the prosecution is saying that the defendant is guilty. And we went through Rule 3.6. I think I actually still might even have it up. Let me see if I do. Do I? I guess I don't. But we went through it, and it essentially is them having the ability to defend their client against publicly known things. And I am totally summarizing that. So, the court expressed concerns about counsel's candor. Baldwin informed no one that a defense outline had been sent to a third party for months until the state discovered it. The court noted prior filings appeared to make factual allegations without foundation. For this right here, if this was so bad, and this is probably one of the worst things that I actually see, even though it was an accident, the fact that he didn't actually notify anybody, why wasn't there anything done then? Why wasn't there any sanctions put in place? Why wasn't there any type of disqualification hearing of Baldwin and or / Rosie at that time? That's actually more grossly negligent, in my opinion. The court noted prior filings appeared to make factual allegations without foundation, which were then disproven. That's so stupid. This record does not contain the transcripts necessary to evaluate those concerns. Yeah, it does not, because none of it does. None of us have seen that. Good job, Attorney General of Counsel. But the concerns raise potential ethical issues and concerns for competent representation. But once again, we don't have any of that. So you can't actually say that that is incompetent or negligent or any of those things, because once again, there's no documentation to back up any of those claims. Counsel's conduct could implicate a conflict of interest or endanger Allen's ability to secure an impartial jury. Defense counsel permitted 2 separate leaks of protected material, including graphic crime scene images. Public dissemination of graphic crime scene images could inflame prejudice against Allen. Because of the extraordinary public attention on this trial, the court imposed a strict protective order on all discovery. The record contains incomplete and inconsistent information regarding the extent of the leaks and counsel's role in them. An affidavit from a friend and former employee of Baldwin's claims responsibility for taking the photos without counsel's knowledge, but a letter from counsel to the court indicates that counsel regularly consulted the same friend about the case and defense strategy. Bingo, I said that the other day when we were talking. It's unclear whether the friend was given access to protected discovery or privileged information during these consultations. I agree with that too. Once again, we don't know because there was no hearing and we were not provided any evidence. The record also does not reveal what law enforcement learned about the extent of the leak or counsel's role in it, and the investigation appears to be ongoing. Investigations into and potential liability for counsel's conduct during representation can give rise to a conflict of interest requiring removal. It all sure can, and by all means, let him have the hearing so we can all figure out if it does, because you're stating that it can, but doesn't mean that it does, because none of us, once again, have seen any of the evidence. The court also expressed concern that counsel obtained a financial interest in the proceedings by filing a notice of tort claim related to Allen's pretrial confinement. Whether circumstances exist that would divide counsel's loyalty between Allen and their own interests is unclear. Once again, making statements when you don't actually know. The record is also inadequate. Really, a lot of this should go towards the fact that the first writ talks about how her court record is a fucking disaster. And he's literally the counsel for the attorney general is like, yeah, we don't have any clue who's right because the record is so inadequate. The record contains expressions of Alan's desire to retain Baldwin and Rosie after being informed of the leak, but the record does not show what Alan knew or understood regarding the leak, the court's other concerns about counsel's competence, and how those matters impacted his ability to obtain a fair trial or the alternatives available to him. Taken as true, the existing assertions of Alan's preference are insufficient to determine that he is making an informed decision, which is why they should have had a hearing that Richard Allen was at. Hence, Richard Allen's rights to due process are being violated. The presumption of deference to the defendant's choice is strengthened by confidence that it is an informed and individual choice by the defendant. Inquiry and advisements from the court are needed to ensure Allen understands the risks and gains of his choice. Give me 1 second. The court's discretionary decision could be reviewed on appeal with a complete record, but the limited review in this action is inappropriate. Courts have discretion to remove counsel for gross incompetence or inappropriate conduct that cannot be adequately addressed through contempt. This requires more than general concerns that counsel is not handling the case as well as they should. Right, she did. I think we all know that she had concerns. That's the extent of what we do know. But the extraordinary remedy of a writ is not available where the matter is within the discretion of the trial court. And I can guarantee the comeback is everything that they already said, that there is no court records to substantiate anything. So how in the world would any type of appellate attorney be able to go and file an appeal on a court record that doesn't exist? Can anybody make that make sense? Allen has not asked this court to mandate further proceedings, but an outcome. Allen seeks a combination of relief, reinstatement of counsel, removal of the judge, and a trial within 70 days of the writ that would not permit respondent or any successor judge to undertake further proceedings prior to trial. This is inappropriate to decide whether the trial court abused its discretion. Writs may issue to compel lower courts to act on matters within their discretion, but they are not appropriate to dictate how that discretion is exercised. The balance between a defendant's ability to choose representation and his right to effective representation warrants comprehensive appellate review, not the expedited and truncated proceedings here. I think I have a hypothesis that's kind of where I'm gathering is that he's like with the first one, because the first writ is all about how she is a disaster at keeping her record clean. And so it seems like he wants to defend her. And this is my interpretation. If you guys see it differently, like, let me know. It seems like he wants to defend her and say, hey, you know, as a judge, you do have the right and you do have the discretion to remove attorneys that commit negligence or anything along those lines or are incompetent. And it is her right as the judge to do so. But then he's turning around and he's saying, this is what she's claiming. And if all of that is true, then she has every right to do it. But because of this incomplete court record, I can't actually determine if she did the right thing. But he's also saying this isn't the avenue that this should have been done. It should have been done through appellate court. But my point then turns around and says, how do you do it through an appellate court if you don't have any of the court filings and the court rulings to be able to file at an appellate court? So let me just put it to you this way. If they're sticking with Baldwin and Rosie walked in the door and they withdrew their counsel, right? What would Baldwin and Rosie be appealing? Their own withdrawal? Because there's no finding of fact when it comes to them committing gross negligence. There's nothing that says that. She doesn't even say that when she walks into the courtroom. She doesn't even tell the court, at this time, I have found that the two defense attorneys have committed gross negligence, and gave them the opportunity to withdraw or be disqualified. She doesn't even put that on her own court record when she walks in the room. She says they withdrew. She also acts like she's so surprised about it. Now, as the attorney, what would I go and appeal? What do I appeal? There's nothing for me to appeal. I need to look more into the interlocutory appeal, because that's the only one that I was kind of questioning before any of this happened. So I think the Attorney General wants to take her side and says, yes, she has the right to do all of this. And also says, you attorneys that are filing this writ are going about it the wrong way. But then he's like, well, I can't really say one way or the other because I don't have the proper court records to be able to tell you. The request that the court order trial to commence within 70 days is improper, as Allen has not requested this relief in the trial court because he didn't have a chance to. And now the new attorneys don't want it. The new attorneys don't want that because that would not be good for Richard Allen either. It would not be good for anybody if they went to court within 70 days with new attorneys. So it has not been requested that, but they want it. They want the 70 days after they have the attorneys reinstated. So that's neither here nor there. Allen has not moved for an early trial under Indiana Criminal Rule 4. Allen points to the fact that he signed a motion in August 2023 requesting an early trial that has purposefully not been filed with the trial court. True, a trial court cannot act on a motion that has never been presented to it until the trial court has shown by some ruling or refusal to act that it's exceeding or failing or to exercise its jurisdiction. There is no basis for action. Well, right now, of course, there isn't, so they can't just rule on that part. That makes sense. Allen can file a motion for early trial at any time, and the trial court must set the trial date within 70 days. Yep. This is when we talk about, everybody's like, he waived his right to a speedy trial, which I still can't even find where the hell he waived his right to a speedy trial. And I still have never found where he waived his right to a preliminary hearing, but whatever. It's out there somewhere. I just don't have any idea where it is because everything's not clear. The record's just not clear. But he has the right at any time to reinstate his right to a speedy trial, which is what they were intending to do. And they also stated that, according to Baldwin and Rosie, they stated that when they were on the phone with the judge. Because Allen has not yet requested an early trial, it is improper for him to ask this court to order that relief in the first instance. Now, for 3, the request that this court replace Judge Gull is improper, as that request has not been properly presented to the trial court. Here's the issue. The Supreme Court is who put Judge Gull in place, so I'm not sure that that's going to work. But because this is the court that actually put her there. As his third request for relief sought, Allen asked the court to remove Judge Gull and appoint a new special judge. This request is improper, as Allen has not asked for this relief from the trial court. It is true that after he withdrew, Rosie filed a motion to disqualify. However, at the time that Rosie filed the motion, he was no longer Allen's attorney. So Judge Gull did not take any action. This is the whole point of why the writ is at the Supreme Court, because he's saying he did not withdraw. Well, he's saying that he said he was going to withdraw, but he never did it. So Judge Gull did not take any action on the motion, and that is an understatement. She did take action on the motion. She had it removed from the docket, and I don't like that they're trying to act like she didn't do, and she took no action. That's not true. That is a blatant mistruth. Allen cites no authority that a trial court must entertain motion by an attorney who is not the party's current attorney. Allen does not meet the condition precedent of 2A because Allen did not first request this relief in writing from the trial court, and it is improper to request this relief now. Further, Allen fails to show that a remedy by appeal is not adequate. Current counsel could have filed Rosie's motion or sought interlocutory appeal on the refusal. The appellate process is adequate to correct any abuse of the respondent's court discretion in denying relator's motion for change of judge. A writ is inappropriate because Allen has a remedy through the appellate process, but he doesn't. He doesn't, because anything that was happening with those attorneys who were still his attorneys of record or not, like that's the whole thing. Once again, there's your gray, and nobody has a clear answer. He can file his motion for change of judge, and if denied, he can appeal that decision. He can file his motion for a change of judge that then goes to, guess who? Judge Gohl. And when she denies it, then he can go ahead and file an appeal on that decision, because that's what he should be focused on instead of the murder trial. Whatever. Finally, Allen only points to the judge's rulings in this case to argue the judge is biased. This is not sufficient. The mere assertion that certain adverse rulings by a judge constitutes bias and prejudice does not establish the requisite showing of personal bias or prejudice. Even if properly before the court, this court does not support a change of judge. This record, even if properly before the court, this record does not support a change of judge. Well, that's kind of where we're at. Because the precise relief requested by Allen is not appropriate for resolution in this original action, this court should deny the writ. And there you have it. Don't fight with each other. Don't fight with each other. And I appreciate Lynn being here, so please do not be mean to Lynn. It's probably hard enough for her to go into a chat that has a lot of disagreements with how she feels about things, but I respect her opinion, so please also respect it. They are only liberal when they are paid off for covering up for colleagues so they don't go to prison. As long as they call it gross negligence. Hey, Mary. It's very telling that even judges are scared in this part of Indiana if they don't go with the flow. Yeah, and that's why I said, because here's the thing, is she's making her statements based on what her life is, and that's what everybody does. No matter what chat you go to, no matter where you go, you guys have to remember that we're all basing our decisions based on the life that we've lived and the knowledge that we have on different circumstances and the way that we perceive things. It doesn't make any of us right, wrong, bad, good, because here's the thing: the next case, we could all agree, and then we'd all be best friends. And so I will not fight with people who don't agree with me, as long as they don't fight with me, because they don't agree with me. Hi, Queen. Good to see you. How's mom's? Hey, Steve. How was it Kathy Allen didn't suspect her husband after his interview with Dee Dee and watching the BG video, Elephant in the Room? I've wondered this, Steve, and I think if he is the guy, because I do think that, no, it's okay, brutally honest. I know it gets heated because everybody has their, I do it too. I do it too. So I know. I'm just saying. But I have wondered this, Steve, because if he is the right guy, which there, and I'm still on the fence that he absolutely could still be the right guy or not. But I think that if she knew he was at the bridge that day, and she even slightly suspected, hey, I think that might be that kind of looks like my husband walking. It kind of looks like the clothes that he wears. It could possibly be him. It kind of sounds like him. I think the audio is so distorted that I think that nobody should even use it, but that's my personal opinion. I think that if he went and talks to Dan Doolin, or if he did talk to Skinner or whoever the hell he ended up talking to, and nobody ever came to talk to him again, I think that you would just start to think, okay, well, maybe he's not the right guy. He's not the right guy. No, nobody's talking to him. So that must not be him. That's the only thing I can come up with, really, is why I think that there's a possibility that she would have let it go. Or maybe she's just adamant that it's not her husband. And she's like, there's just no way. There's just no way. No. Well, the only thing we ever heard, I don't know if you guys remember this, But after he was arrested, somebody went back and was like looking at 4chan, and somebody had mentioned the name Richard. They never said his last name. Somebody had mentioned the name Richard, which I thought was interesting. And then at one point, if you look at the history on Wikipedia, somebody had changed the person's name to Richard instead of like suspect or whatever, or bridge guy, whatever the word was. And they changed it to Richard, and then they changed it, and somebody else changed it back. I just think it's so interesting. Nobody ever said Richard Allen, but somebody was thinking it was a Richard out there somewhere. But as you know, they've said kind of repeatedly, is that he really liked to be called Rick. Oh, for fuck's sake. Hold on, did you say something up here? They literally have no physical evidence except an unspent round from RA. See, that's how I feel. And that's why I'm like, I just like people. I like people's thoughts. I like to have the conversation. It helps me to put things in perspective on what other people think or where people are coming from. It's kind of why I like the whole YouTube interaction. But I can't handle the fighting. That's the part that just gets me. For fuck's sake, I'm in agreement with you. As of right now, that's the big piece that I can see tying him to it, which also then makes me go, is it, they filed a motion in limine for the defense attorneys had filed a motion in limine for the bullet. Nothing's ever been done with it, because they also ended up they wanted the suppression hearing, and they were going to file the suppression hearing what was it, June, July? It's in the summer. I always get them mixed up which month it was. And the judge is actually the one that requested for them to go ahead and put their suppression motion into a Frank's motion. And in doing that, how we ended up where we are now with the Frank's memorandum and everything that's happened since. So both of those motions that have anything to do with the bullet are just up in the air. It's interesting. Do you do it? You do not. Do you, Yaya Kelly? Do you do it for fun, or do you do it like to actually make sure the facts are right? Hi, C-Dub. What's the gist of what's happening? I'll absolutely read it. I'm dying to know what's going on. Okay, so right now we just finished going through. The Attorney General of Indiana has submitted a response to the second writ. We just read that. We're about to get into Judge Gold's response to the second writ. Oh, you think saying that will? Oh, great. That's funny. What letter? Sorry, I missed whatever this was. I can tell you my ex-husband was a sheriff of a huge area in California. He said the PCA was the weakest he'd seen in 25 years. It's a pretty bad PCA. I agree. From somebody who reads a lot of them, I've never written one, though. A squirrel could have carried and buried that shell casing. Yeah, or it was on the bridge at some point and the girls picked it up. That's very possible. Hi, Candace. Gold's response is almost the exact same as the AG. Oh, shit. Seriously? After hi, Jay Turner, by the way. The last hearing, Bob Motta mentioned Kathy Allen was adamant that the man in Libby's video was not Richard Allen. He did the pics for free for the Patties, and they did not suspect him either. So if they didn't, how can we say the wife should have? I would think the wife probably more so than even the Patties, though, because for me, looking at the video and the audio, I guess well, you know what? I'm going to say it depends. Did they see it? Did they see the footage raw? And also, did they really see him walking around? I don't think they knew him, though. I think it would be just a big difference in knowing somebody. Like, I know my husband's walk. I know the way my husband holds himself. I know what kind of clothes my husband would or would not wear. which is where the whole clothes thing comes in, because it's like, I feel like, in October of 2022, they're like, does he typically wear like a jacket? And she's like, yeah. And then like, what kind of jacket? And he's like, windbreaker, Carhartt, whatever. And they're like, oh, so that's what he would typically wear. Hi, Deets. I called it. She's not going to recuse. She's so fucking stubborn. I haven't got there yet. I don't know when the letter was received by the judge. Are you talking about Richard Allen's letter? There was casings all over the property, supposedly, but only that one matched. The unspent bullet is subjective, the prosecution's own specialist said in that document, which I could remember which one, but basically said the results depended on who was looking at it. I have those. And I think I actually have them labeled now. Let's see if I do. Then we got to read hers. This is an identification opinion is reached when the evidence exhibits agreement of class characteristics and sufficient agreement of individual marks. Sufficient agreement is related to the significant duplication of random striated impressed marks. I don't think it's this one. I think it might be the other one. Maybe it is that one. This is the cartridge, and item 16 was identified as being cycled in the firearm, and item 314 from Indiana State Police Laboratory. Maybe it is this one. It might be in the motion of limine, and that I don't think I have readily available, but that's okay. I'm wondering, did I stop at the sentence before it, Ariel? Did I really? Let me go back. The interpretation of identification is subjective in nature, and of course I did, Ariel, because this is the whole thing. I always tell myself, just keep reading. Keep reading. The interpretation of identification is subjective in nature and based on relevant scientific research and the reporting examiner's training and experience. Yeah. Now, why do I think that they would? I think they probably would have tested a lot of them. They would have tested a lot of the rounds. Hold on. Now, Julie Melvin had said that she had randomly talked to some of the people that were from Indianapolis who were asked to come down and help. And weeks later, they were down there and they had found a bunch of .40 caliber casings. So I think that it's interesting because they also had gone to Brad Weber's and looked for they took his Sig Sauer. So now, did they rule out just this one? Did they find the guns that had matched the other spent rounds? And that this was the only one left, or this was the one oddball that didn't match anything else? I don't think we know any of that. I don't even know if that's something that we would ever learn in the trial. We'd possibly have to ask, for more of the discovery information that wasn't used at trial afterward. I think they were hoping to get more after the arrest. Even a first-year public defender could eat away at the casing argument. Yep. Give me 1 second, you guys. I'm going to grab another drink. Okay. RA told his wife he talked to Ellie and they cleared him, so she chose to believe she wasn't married to a murderer. Or she believes that she's not. I mean, that's kind of I think that, and there's a lot of people who say they were cleared, but that police have publicly said that nobody was cleared. I think that, Lynn, that's what I'm waiting for, because I don't see the human element yet. So even if the bullet stays, it's open for a lot of interpretation. And I don't know how many trials you guys have followed, but like one case that always has bothered me is Casey Anthony's case, because those experts got on the stand, and even though what they were saying was absolutely valid and important, a lot of the jurors afterward said they didn't understand what the experts were saying. It didn't make sense to them. It wasn't explained simple enough, or whatever, in layman's terms, or however you want to put it. It was too confusing. So they kind of just washed it like to the side. And that's what happens in a lot of trials. It becomes a battle of experts, and like who you like more and who you don't, you know, as a juror. The bullet was found in a floodplain of Deer Creek, and RA lives close to a stream, which is, well, that's interesting. That's a very interesting argument too. They could bring in some experts that could show how that could happen, depending on where he would say that he actually used to fire, that he would fire this gun, or what do they call it, rack the, I'm not a gun person, you guys, so this is right. Yeah, gun stuff is not my forte. You got to go with probable versus possible versus probable. That's gonna suck. Are they really? All right, well, let's get to it. Maybe he was shooting chipmunks like Barry Morphew. Okay, so this is the respondent's brief in opposition to the relator's verified petition for the writ of mandamus. So from my understanding, Annie, they can, because the extractor mark, somebody who knows guns better than me, I don't know where Sniper is, but Sniper always helps me with my gun stuff, that what the part that's hitting the back of the casing, the part that's hitting that is going to leave a mark, and if that mark matches that gun, that's where they're getting that from. It's not even about the striations and stuff, because it's not being cycled through the actual gun. I mean, it's not being shot, so it's not the striations necessarily. I just like that it's another magic bullet, and goes with the other conspiracy case that I've ever thought was really a conspiracy. Nope, I do not, and nobody can. Everybody answers differently. What has Goal said? We're about to read it, my 3 cents, so you just got here in time. Yeah, not if mass produced. So, and I don't know. I have a hypothesis. Do you know when that really started to become a big thing, where guns were more mass produced versus individual? Because do we know what year his Sig Sauer's from? And would it be something that would have been mass produced? That's what I don't know answers to things of like that. And that's if chain of custody checks out. Right. That's another big thing. That's another if. There's all kinds of steps. Yep. Bullet has no chain of custody. It's garbage. Doesn't really matter. Still, that bullet is not conclusive. Bullet could have lifted from a shooting range where RA practice and does not have strong chain of custody. Well, I think that the biggest argument is if there, okay, let's just say that there is chain of custody. It is there. There's experts up there. My biggest thought would probably be is to show that, like, how many different ways it could have gotten there. Like Steve was saying, if he shoots in that area, even though he's never shot there, and it is a floodplain, that's a pretty big deal, especially if they can prove other items that were in this floodplain, trash or whatnot, came from somewhere else and landed there. That would be a huge deal. And the bullet was not in Ron Logan's search warrant, which is why, for me, I've always thought that it had to have come after March then. They had to have found it after they searched Ron Logan's. That's what I think. Otherwise, it's really weird that it wasn't in there. C-Dub, no, I didn't. I can't. So Kennedy is something I always studied with my dad, and I haven't been able to watch anything on it since he passed away. I went to Dealey Plaza with my dad a couple of years ago. It wasn't in the Ron Logan one. It's in the PCA, yes, of Richard Allen. But I'm talking the search warrant for Ron Logan doesn't have a bullet. See there, sniper. Extractor and ejector tool marks will be, the ejector, that's the one that I was looking for, will be present on the side and rim of the casing. However, being unfired, the markings will be less evident due to the casing not being hot and no breach marks. Okay. So the extractor and the ejector will be marked on the side and the rim, which is the back part. I know that. However, being unfired, the marks will be less evident due to the casing not being hot. So it can't make any of the striation marks on the sides is really what I'm gathering from that, right? Yeah, one day I'll watch it. One day. I saw that it was out, but I couldn't do it. They didn't need to put any gun info in Logan's warrant. He was on probation. He's not allowed to have any guns on probation. Right, necessary evil. So what they did is on March 6th, they went there and were able to search for any guns, any ammo, any of that kind of stuff. But it's interesting because in the 17th warrant that the FBI files, they talk about how there's articles of clothing missing from the girls. It talks about other things, from the crime scene, but they don't mention the bullet. And because we don't have anything from the 6th, we have no documentation from the 6th when they went in, which they could because of his probation, and they wanted to see if, take his guns and his weapons. Did they have it then? And that's one of the reasons they were taking all of that? Possibly. But it's still weird that in the search warrant, they don't talk about the bullet. That's my only thought on that. Because I know they went twice. Because they needed the other search warrant to be able to look for other stuff and search all the other places on the property. Well, they supposedly found the bullet between the girls. Now, if they didn't find the bullet the day they found the girls, then how would they have known it was between the girls? But see, here's the counterpart to that. So you guys remember there's the whole the Discovery thumbnail that was accidentally sent to Brandon Woodhouse. Supposedly, I do not have this, so this is grain of salt. Take it for what you want. Supposedly, it says on there that the bullet was logged on the 15th. Now, when I asked which 15th, nobody seemed to know the answer to that. Because I'm like, was it February 15th? Or was it March 15th? Or was it April 15th? Like, 15th of what? Oh, no, you're fine. No apologies. Wasn't his more of an older model, I think. That's what I was wondering. They were looking for a Sig Sauer, for sure. But how did they do that? Like, what process of elimination? Just a regular 9? Yeah, I don't know. I don't even know how many guns they ended up taking from him. Okay, let's see what she's got to say. Everybody's saying that it's pretty much the same. She already made her decision, regardless if they would have gone out there or not. This was her decision. That's the problem. Yeah, I agree with you, BH. I absolutely agree with you. There wasn't any going out there. So here's her table of contents. And then here's all the case. Oh, there's a lot of case law. There's some more. Oh, we should compare those when we have time. Introduction. Coffin Dapper sucks. Thank you. Sometimes I feel like they're all over the place. Like the last one, I don't even know. I was like, I don't even know how you guys stuck it out with me for so long. Okay, so this court has never issued a writ to reinstate a criminal defendant's counsel whom the trial court removed for engaging in multiple acts of gross negligence, causing the trial court to conclude that the accused was not receiving competent representation. In disqualifying relator's counsel, respondent did not violate an absolute duty. Moreover, relator's remedies on appeal are wholly adequate. Are wholly adequate? Remedies on appeal are wholly adequate? Am I reading that correctly? Appellate courts in Indiana and across the country routinely resolve issues regarding a criminal defendant's Sixth Amendment right to counsel of his choice through the ordinary appellate process. Whether relator's counsel withdrew or were removed, this court should deny the petition. Relator's petition further fails on the merits. Relator's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select his counsel. Respondent has discretion to remove relator's counsel where, as here, the record supports that attorneys Baldwin and Rosie were providing ineffective assistance of counsel. I'm going to struggle with this. Relator's counsel, one, failed on multiple occasions to take reasonable steps to safeguard confidential case materials. 2, made extrajudicial statements that had a material likelihood of prejudicing the case. And 3, provided false information to the court. Before removing relator's counsel, respondent afforded relator with notice an opportunity to be heard through written submissions as well as argument in chambers and on the record in court. Relator's request for this court to disqualify respondent fails because respondent alleges no bias or prejudice against relator or his current counsel. Relator's lone assertion for respondent's removal is the trial court's ruling to disqualify relator's prior counsel. But a trial judge's adverse rulings are insufficient to demonstrate the judge has a personal bias or prejudice. This court should deny the petition. Oh, gosh. The Supreme Court has the power by writ of mandate and prohibition to confine a lower court within its lawful jurisdiction. Writs of mandamus and prohibition are extraordinary remedies which are viewed with disfavor and may not be used as substitutes for appeals. That's like the big thing that I think all three responses have had. This court will not issue a writ unless relator has a clear and unquestioned right to relief, and only where the trial court has an absolute duty to act or refrain from acting. This court has never issued a writ to reinstate counsel where, as here, the trial court removed counsel based on the court's reasonable findings that counsel had engaged in multiple acts of gross negligence, compromising the accused's constitutional right to competent assistance of counsel. And contrary to the relator's assertion, neither this court nor the United States Supreme Court has held that a trial court may remove an accused selected counsel in two circumstances only. The one where the counsel is not a member of the state bar, or 2, a conflict of interest. Relator does not have a clear and unquestioned right to the relief he seeks. To the contrary, this court in state whatever denied the relief relator requests here. Okay, so state versus Jones. The relator, who had been indicted for murder and rape, requested a writ of mandamus to reinstate his attorneys whom the trial court had removed. The court denied the petition. I'm just going to copy this real quick because I want to see. I'm going to pull this up in a minute. So give me just a second. Never mind. I guess I won't let me do it from here anyway. That's fine. I'll pull it up in a minute because I want to see if any of you guys want to or can pull this case up and see why and how the attorneys for this case were actually removed from the case. and if it's similar to what we're looking at now. Because there's, they're using it and saying like the court denied that petition, but I'm wondering. In dictum, the court observed that it was generally of the view that a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. However, the court finds it unnecessary to explicate the parameters of that authority here. The court's dictum in State v. Jones does not provide relator with a clear, unquestioned right to relief or establish that respondent violated an absolute duty. Relator relies for the most part on cases from outside of Indiana, but these cases are not binding on the trial court, much less do they impose on respondent any absolute duty to act. When interpreting the Sixth Amendment, the trial court must follow the law of Indiana's appellate courts and the United States Supreme Court. Relator identifies no case from this court or the United States Supreme Court that affords him a clear right to an extraordinary writ for the relief he seeks. All petitions shall state facts showing clearly that the remedy by appeal will be wholly inadequate. Far too frequently, writs of prohibition and mandate are sought to be used as a shortcut to an appeal on the merits, which cannot be done. If the relator believes that cases from other jurisdictions are persuasive in how respondent should interpret the Sixth Amendment, relator may present those arguments on an interlocutory or direct appeal. Let's see. March 22nd, the attorneys filed a motion to reconsider and the alternate to withdraw as counsel. The motion began as a mock letter to Jones, which concluded, if you are convicted, it will be without the benefit of effective representation, due process, or other protections in the U.S. and Indiana statutes. Have a nice day. So the attorneys filed a motion to reconsider and the alternate to withdraw as counsel. The motion began as a mock letter to Jones, which concluded, if you are convicted, it will be without the benefit of effective representation, due process, or other protections of the U.S. and Indiana constitutions. They basically said, grant this motion or let us withdraw, and then the court removed them. And the motion was for a motion to reconsider. Do we know on what? Ariel, did you know a motion to reconsider what? Oh, do you, Kev? I didn't know that. Hold on. I didn't think that they actually could do that. I'll have to look more into it because it's not coming up on just these documents right here. Motion to reconsider a ruling that now DNA evidence disclosed by the state after a certain date would be admissible. The court ruled that no evidence disclosed by the state after March 20th would be admissible, and that the state would not be allowed to present DNA evidence before April 3rd in order to allow the defense expert time to evaluate it. On March 22nd, the attorneys filed a motion to reconsider, or in the alternative, to withdraw as counsel. I'm wondering, was it so close to trial that that's why? That doesn't line up with this, though, still. Now we're talking. So anybody who's confused for just a second, we're talking about the case that was cited. Ariel's typing in what the case that was cited, that versus Jones, State versus Jones case that they used because of it being denied that those attorneys be reinstated. But that it seems like a completely different situation. So what I just read from Ariel is not about Richard Allen's case. It's about a case that was being used for precedents. Just FYI. So it's a different case, not this case. It is a case they used and cited that it should be viewed as the same, and that's why one of the reasons they're stating that this writ should be denied. If the relator believes that cases from other jurisdictions are persuasive in how respondent should interpret the Sixth Amendment, relator may present those arguments in an interlocutory or direct appeal. We just talked about that. Relator cannot file an original action to circumvent the normal appellate process. Indiana's appellate courts, as well as other state and federal appellate courts, routinely consider Sixth Amendment challenges on an interlocutory or direct appeal, including disputes about choice or removal of counsel. It cites a whole lot of cases there. Notably, relator cites this case and in his petition and brief all cases on appeal. Those cases defeat relator's assertion that his remedy available by appeal would be wholly inadequate. Well, not necessarily, because she's removing anything that they have from the docket and would not give them any of the information. We also note that in our review of the cases, Jones cites to us in support of the proposition that a judge's authority to remove court-appointed criminal defense counsel is limited. We have found none where the removed counsel had previously indicated a desire to withdraw if the proceedings were not conducted in the way they favored. But having indicated their desire to withdraw from the proceedings, if not conducted in the way they favored, will not be countermandated. The trial court's ruling that placed Dillon in precisely the position their motion indicated their willingness to be. Yes, I agree with that. They chose it, so it's not the same. It's not the same. I don't know how it's being used, but it's not the same. Relator asked this court to use an original action to rule for the first time in Indiana that the Sixth Amendment prohibits a trial court from removing counsel whom the trial court has reasonably found to have been grossly negligent. But this court will consider an extraordinary writ only when the law is settled and the trial court's duty is absolute. This court should decline relator's invitation to use an original action to alter Indiana law. But there's no finding. This is my whole issue. There's no finding of any type of gross negligence. They keep saying she found it, but she didn't actually do anything with it. A criminal defendant's Sixth Amendment right to effective assistance of counsel outweighs his limited right to select counsel. The Sixth Amendment to the Constitution guarantees that in all criminal prosecutions, the accused should enjoy the right to have the assistance of counsel for his defense. The essential aim of the amendment is to guarantee an effective advocate for each criminal defendant rather than to ensure that a defendant will be inexorably represented by the lawyer whom he prefers. Inexorably. That's not right. So they're fighting the same thing about the Sixth Amendment, that she has a right to remove them because they're court appointed. As this court has explained, the right to counsel in a criminal proceeding does not mean the defendant has an absolute right to be represented by counsel of his choosing. The appointment of pauper counsel is within the discretion of the trial court and will be reviewed only for abuse of that discretion. Problem is, she found them grossly negligent after they were pro bono, and not even in a court finding, just in her own finding that she says she has. The qualified right to choose one's own counsel must be placed against the backdrop of judicial discretion. Traditionally, courts enjoy broad discretion to determine who shall practice before them and to monitor the conduct of those who do. The Sixth Amendment's rights to choice of counsel merely informs judicial discretion. It does not displace it. The trial court is granted considerable discretion to remove counsel so that the trial court has the tools to preserve an accused's Sixth Amendment right to competent and effective assistance of counsel. This court has explained that the trial court must be given latitude in its efforts to navigate whatever those are posed by the conflicting Sixth Amendment rights, the scila and carbidus, posed by the conflicting Sixth Amendment rights to counsel of one's choice and to competent counsel. This is still going to be my same issue. She doesn't have a finding of them being incompetent. She just says she does. We conclude that the trial court discretion is necessary because the tension between these two important rights that must be resolved by the trial court. Gross incompetence or contumacious conduct that cannot be cured by a citation for contempt may justify the court's removal of an attorney, even over the defendant's objection. Moreover, the trial court need not delay taking remedial action until counsel's incompetent representation causes the entire trial proceedings to be constitutionally defective. We must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. Affirming disqualification of defense counsel on the grounds that the trial court has an obligation to foresee problems she has an obligation to read between the lines, essentially, over representation that might arise at trial and head them off beforehand. The trial court retains the discretion to remove counsel to preserve an accused's constitutional rights to effective assistance of counsel and due process. Okay. She is creating these findings that she doesn't even talk to Richard Allen about, when they're all, and if you even just reading this, it all talks about the accused's constitutional rights, but she doesn't even have a conversation with him about his own constitutional rights and why it's important that she does remove them or doesn't remove them, because he's not allowed to be there for any of them. And so she's foreseeing problems over his representation, but doesn't have the ability to self-reflect on the problems that she's causing with the perceptions of prejudice to the public in one of the most high-profile cases the state of Indiana has ever seen. But the trial court retains the discretion to remove counsel to preserve an accused's constitutional rights to effective assistance of counsel. I don't disagree that the trial court has that discretion. I just disagree with the fact of how she went about it. I think that some of these arguments are, what do they like to call them? Moot points. Respondent acted well within her discretion to remove Baldwin and Rosie over relators' objections. The record supports that the trial court could reasonably conclude Baldwin and Rosie committed multiple violations of the rules of professional conduct, compromised relators' defense, and the totality of the circumstances demonstrated gross negligence and incompetence on the part of the defense team. Yeah, well, perfect. Prove it. That was the simple thing. No, you didn't do. Baldwin and Rosie failed to take reasonable steps to safeguard confidential case materials, including crime scene photos. Baldwin's friend and former employee, Mitchell Westerman, went into Baldwin's office conference room, reviewed confidential photos of the crime scene, took pictures of those photos, and shared them with at least one other unauthorized person. The photos leaked to the public, which prompted the police to investigate. Well, unless you ask McClellan, because he says he was doing the investigating for 17 days. An individual whom Westerman shared the confidential photos committed suicide the night after police questioned him. Rosie and Baldwin agreed to use Baldwin's conference room as a home base for confidential case materials. So Rosie understood that Westerman would regularly visit Baldwin's office and that Baldwin would share with Westerman information about the case to obtain Westerman's feedback. Baldwin emailed confidential work product to an unauthorized person, and Baldwin and Rosie failed to timely report the leak to the trial court or the prosecutor. The leak of the crime scene photos was not the first time that Relators Counsel were involved in a leak of confidential case materials. In December 2022, Baldwin sent an email to a person named Brandon Woodhouse, a defendant in an unrelated criminal case, that contained an outline of the discovery materials the state had provided to Baldwin. Baldwin apparently intended to send the email to Rosie. Baldwin and Rosie did not promptly notify the court or the prosecution of this leak. Well, but it wasn't discovery. I think that's part of the issue. And even though I do think they should have reported it, and if they didn't, I do think that's a problem. But once again, this all could be a problem, and they could have done it all in court. Baldwin and Rosie made extrajudicial statements that had a substantial likelihood of materially prejudicing the case. I absolutely 1000% disagree with this. Indiana Professional Conduct Rule 3.6, Baldwin and Rosie issued a press release on November 29, 2022. There was no gag order in place, FYI. They included in their press release detailed extrajudicial statements about the case along with other information that would not normally be revealed and proclaimed relators' innocence. Oh my gosh, they're so bad. Such bad defense attorneys. Baldwin and Rosie did not limit their press release information to that Rule 3.6b expressly permits. When I read it, I believe it did. But, you know, hey, who am I? Nor did they confine the press release to information necessary to mitigate adverse publicity under Rule 3.6c. I believe they did. Baldwin and Rosie knew or should have known that the press release potentially violated Professional Conduct Rule 3.6. Moreover, at the time of the press release, Baldwin and Rosie knew that the state had filed a motion for a gag order, which was pending before the trial court. Okie dokie, nothing was done with it yet. Prior to issuing the press release, Baldwin and Rosie assured the trial court they did not intend to try the case in the media. And there you go. Who cares? They didn't. They followed what was allowed of a defense attorney. Baldwin and Rosie's decision to issue the press release prompted the trial court to issue the gag order until further hearing. Baldwin and Rosie issued the press release knowing that the trial court would likely soon issue a gag order. Okay. Baldwin and Rosie provided false information to the trial court. I'm not aware one way or the other of this. This is an interesting one that everybody seems to disagree on. On or about June 20th, 2023, the trial court held a hearing on Relator's motion to reconsider a safekeeping order. At the hearing, the state presented evidence that clearly demonstrated the falsity of Relator's claims. On July 19th, the trial court issued an order on the motion finding that the evidence presented at the hearing did not support many of the allegations advanced by defendant counsel. In fact, the evidence presented demonstrates that the defendant is treated more favorably than other inmates housed at the Westville Correctional Facility. This is based on the guards and the warden of that Westville Correctional Facility, FYI. That's just ridiculous to me. And we saw the letter, whether you want to believe it or not, is a different story from the other inmates who talked about how they've seen him being mistreated. As a result of these events, the trial court became gravely concerned with Relator's right to have competent, non-negligent representation. The record demonstrates that the trial court, based on the totality of circumstances, could reasonably conclude that the counsel's representation of Relator fell objectively short of the prevailing professional norms and that counsel's deficient performance prejudiced the defense in violation of Relator's Sixth Amendment right to competent counsel. Here's an interesting thing. Notice on the Attorney General's, it talks about how the record is not conclusive. And then here it talks about the record demonstrates this. But the Attorney General was like, no, I don't think it does, but it might, I guess. Okay. Counsel is ineffective where, one, counsel's performance was deficient based on prevailing professional norms, and two, the deficient performance prejudiced the defense. We don't have any finding of any of that stuff. So that's what those cases found, but she has no finding of any of those. The professional norms in Indiana are violated when counsel fails to safeguard confidential case materials, provides false information to the court, and makes extrajudicial statements that are likely to prejudice the case. And respondents filing complaints against Baldwin and Rosie with the disciplinary would not have ensured that Relator would receive competent representation throughout the remainder of the proceedings. But she still probably, I believe she still has to do that. Whether she removes them or not, I think that she still has to actually submit it. The trial court's decision to remove Baldwin and Rosie did not violate Relator's Sixth Amendment rights. Wouldn't the person who has any thought on his own Sixth Amendment rights have a say in any of that? Relator argues that removal proceedings should occur at a hearing where the defendant has and his chosen counsel are provided notice and an opportunity to be heard on why the attorney-client relationship should be severed. Yes. Relator cites no Indiana rule, statute, or case requiring notice, a hearing, or an opportunity to be heard. In any event, the record confirms that respondent provided relator with ample notice that the trial court was considering disqualifying Baldwin and Rosie before October 19th, 2023. We're going to go back into this. This is very open for interpretation because I know that there are people who think that, yes, they should have known. They should have known that what was happening on October 19th. But I don't know how they should have known unless they're reading between the lines that October 19th was going to be a disqualification hearing because she didn't schedule a disqualification hearing. She scheduled a status conference talking about and other issues that had arisen, but she didn't write it in a legal way that they would have known. But they could read between the lines, and as she says, you're attorneys, it's kind of your job. On October 11, 2023, Relator wrote a letter to respondent requesting that Baldwin and Rosie continue to represent him and acknowledging that the prosecutor was seeking Baldwin and Rosie's disqualifications. Guess what? Doesn't matter what the fucking prosecutor wants. The prosecutor doesn't get to determine whether Baldwin and Rosie are disqualified. That's another problem. On October 12, 2023, Rosie wrote a letter to respondent arguing why he and Baldwin should not be disqualified. On the morning of October 19, 2023, an attorney representing Baldwin filed a memorandum regarding possible disqualification and sanctions. Relator had adequate notice and opportunity to argue against respondent's disqualification of Baldwin and Rosie. No, Relator did not. Relator is Richard Allen. Because they're saying that he had the proper notice because he wrote that letter on the 11th, but he didn't get to talk to anybody. Who was he supposed to argue with? He asked to talk to her, and she said no. I don't know if I don't necessarily think I agree with that statement. Baldwin and Rosie also had the opportunity to proceed with the scheduled court hearing on October 19, 2023, but chose to withdraw instead. I feel like I'm just repeating my same argument at this point. At the October 31st, 2023 hearing, Baldwin and Rosie further argued against their disqualification after filing new appearances, and the trial court afforded them an opportunity to be heard on the record, including via Baldwin's counsel. The trial court afforded Relator adequate process. Relator's assertion that respondent must be disqualified because she removed Relator's former attorneys is flawed. Baldwin and Rosie no longer represent Relator, and Relator does not assert that respondent has any personal bias or prejudice toward himself or his current counsel. I'm pretty sure that's exactly what they did say. Not towards the current counsel. Well, I mean, she's biased for them. I think that was also stated. Second, on the merits, Relator presents no relevant facts supporting Relator's assertion that respondent is biased or prejudiced against Relator's former counsel. There's no relevant facts supporting that? I guess that's open for interpretation, and that's what the Supreme Court's going to have to decide. Judges have an affirmative duty to preside over cases unless disqualification is mandatory. A judge shall hear and decide matters assigned to the judge, except when disqualification is required by Rule 2.11 or other law. Disqualification is mandatory in the rare instant that the judge displays a personal, individual bias against the litigant or the litigant's lawyer. Well, that's what they're claiming, so yeah. Moreover, as the commentary to the Code of Judicial Conduct emphasizes, a judge's unwarranted disqualification compromises the system of justice. Unwarranted disqualification may bring public disfavor to the court and to the judge personally. The dignity of the court, the judge's respect for fulfillment of the judicial duties, and a proper concern for the burdens that may be imposed upon the judge's colleagues require that a judge not use disqualification to avoid cases that present difficult, controversial, or unpopular issues. Well, that's also interesting since they let Diener step down for that reason. The law presumes a judge is unbiased and unprejudiced. To overcome this presumption, the relator must demonstrate actual personal bias. I think that's what they're doing. Or that's what, I mean, actual bias or prejudice exists only where there is an undisputed claim of judicial bias or the judge has expressed an opinion on the merits of the controversy before him or her. Adverse rulings and findings by a trial judge are not sufficient reason to believe the judge has a personal bias or prejudice. I don't think it has anything to do with adverse rulings or findings. It's the fact that they took her, she had them in her chambers and read a statement that she'd already written where she was disqualifying them without a finding of facts. Adverse rulings and findings by a trial judge are not sufficient reason to believe the judge has a personal bias or prejudice. Well, they're not adverse. There was no finding to begin with. The mere assertion that certain adverse rulings by a judge constitutes bias and prejudice does not establish the requisite showing. Respondent removed Baldwin and Rosie from representing relator on October 31st. Respondent appointed new counsel Robert Scremin and William Liberato to represent relator. Relator is represented in this original action by Mark Lehman and Kara Winicki. Relator accuses respondent of exhibiting bias or prejudice exclusively towards Baldwin and Rosie. Relator never suggests the respondent is biased or prejudiced against relator or his current counsel. I don't know exactly how it was worded, so I can't say one way or the other. I don't remember. Given that Baldwin and Rosie are no longer counsel of record, relator sweeping assertions that for all rulings going forward, the public will question the judge's impartiality, and that a new special judge must be appointed to restore the public's trust in the integrity of the judicial system, amount to blind speculation. I disagree. I think that some people are going to have a problem with her in general. I don't whether these people stay, whether the old attorneys come in or the new attorneys leave. I don't think it matters. People are going to question her impartiality no matter what. Not everybody, but I think they will. Even if Baldwin and Rosie still represented relator, respondent has exhibited no actual bias or prejudice against them. Relator offers a scant 2 sentences to support his assertion that respondent has exhibited bias or prejudice. According to relator, respondent's finding that counsel were grossly negligent and publicly proclaiming that she had grave concerns about the representation warrant respondent's disqualification. No, it's about the actions. It's about the actions that you're leaving out. But a judge's findings adverse to a party do not show or even imply bias or prejudice. Further, these findings do not demonstrate actual personal bias. Respondent did not state that she had grave concerns about Baldwin and Rosie personally. Rather, she had concerns only about the representation of relator and his right to competent representation. Respondent's legal findings regarding Baldwin and Rosie, typo, and Rosie's representation are insufficient to overcome Indiana's law's presumption that respondent is unbiased and unprejudiced. I think that this whole thing right here is the issue. Relator requests this court to reinstate the January 2024 trial date, but relator's counsel requested the trial continuance because counsel will not be ready to go to trial. We already know that because they're new, blah, blah, blah. What they want is the old attorneys back on. Then the trial to commence in January. They're just trying to work around that. Amicus, Indiana public defender, argues that the trial court's appointment of relator's current counsel was procedurally defective, but relator raises no objections to the respondent's process for appointing new counsel to replace Baldwin and Rosie. Amicus may make arguments in support of relator's request for relief, but the court should not entertain amicus's separate request for relief. Neither IPDC nor relator assert that Relator's newly appointed counsel, one of whom, as the IPDC notes, is Allen County's chief public defender, is incompetent. The IDPC merely claims that the trial court circumvented the county's comprehensive plan for public defender assignments. However, the trial court has discretion to appoint counsel other than counsel provided for under the board's plan when the interests of justice require. The trial court's method of appointing Relator's new counsel did not violate Indiana law, the Sixth Amendment, or any other absolute duty under the law. In conclusion, respondent, the Honorable Francis Siegel, respectfully requests that this court deny Relator's verified petition for writs of mandamus and prohibition. All right, you guys. Let's see what you guys have to say. Why is the judge persisting in this? It's the interest of justice for the trial to proceed ASAP. She does not seem interested in justice. I just think that she liked, there were shortcuts. My personal opinions on the gross negligence and the incompetence it's very different than a lot of people's. I get it. But I don't know why she wouldn't have just done it straight through. But they're saying here that she didn't do anything wrong, that she's allowed to just call him into her office and tell him, hey, sorry, guys, I found you guys to be grossly negligent. They're saying that that's how it is under Indiana law. The only way it can make sense is if Gull actually has inside information of further negligence. Well, and that's possible because McLeland and her obviously had some type of ex parte communication for him to bring people in early. And that is a big deal to me. It always has been. Hold on, I think I have a tiny human that just got home from school. Let me say hi to him. Okay, sorry about that. Why is she lying about the date she removed them, the 19th, not the 31st? Well, I think that's my whole. I feel like I'm on repeat, and I apologize for that. But my whole thing is how gray all of this is, and how they keep trying to go like around the actual facts of it, because she didn't actually remove them on the 19th. When she says that she had a finding of gross negligence, she acts like she had that finding on the 19th, but then says that she didn't and that they withdrew. I have so many issues with it because it's just not clear. Why didn't they just put it out there in a clear, easy manner? If you look at other cases, whether we agree or disagree with the judge's decisions, when it comes down to it, we at least know what the judge's decision is and why it is that way. Do you know what I mean? Whether we want to say, yeah, we think that's right, we think it's wrong, whatever. I don't. She just did whatever she wanted to do. She's just like, no, I have a finding of gross negligence. Yeah, why is it? Why is it the Fran Gull show? So irritating. Yeah, she's throwing water in her face and swearing it's raining. That is the best. She really is. She's just like, look, see, it's rain. I did all these things. I found all this stuff. And it's like, you did? And it's like, well, we're just gonna go That's how hi, Humanable, by the way. That's how I feel. I feel like she was just sick of their bullshit. And she was like, I don't really even give a shit anymore. You guys you got to go. And she could have been right on all of those things. But how do we know? How do we know she's right? But you notice, and here's another funny thing, is she actually makes sure that she does not talk about that. She does not talk about that in this response. She does not talk about the Franks memorandum, which I'm also interested in. Gold still has to hear people out in order to make any findings, so let the prosecution chime in. It's a travesty. But so they have these phone conversations, which we can tell that they're having because of the emails that are going back and forth. But there's nothing on the court record. So whatever she is saying to them, whether she's saying, maybe she straight up tells them, hey, on the 19th, come in, be prepared. Maybe she did tell them. Maybe she didn't. Once again, since it's not done with the proper procedure, we have no flipping idea. She has to have hearings to make findings. From my understanding, she sure does. They had a phone conference, but there's no court transcript. There's nothing that says that. There's nothing that says that. That's why there's something that says they had a phone conference, but nothing that says what they actually talked about. How did Nick know to bring a dozen witnesses? Were there back channels between Gull and Nick? If that could be proven, then those are ex parte communications, and then she could be in big trouble for that. Well, this is the tough part, because even if we listen to like all the defense attorneys or all the prosecutors or any type of lawyer on any type of social media, you really have to find the ones that have practiced, as a defense attorney in Indiana, because there's such little intricacies to different laws and how things are done. Then that's why you can see, like, even in the writings here, they're talking about, the relator put in their response all of these things about, or court cases from other places and nothing from Indiana. Well, sometimes that's because there is nothing in Indiana. And that's also why the Supreme Court needs to make a decision on it. And like when we were looking at the Attorney General, they're even saying, like, hey, we need, Colorado just made this law or made this ruling, which now creates case precedent, which matters. This is not going to come down to whether they think that Gull was right or wrong. I can promise you that. This isn't going to come down to like how we feel about it, that she's, or some of us feel about it, that she's a little on the shadier side and should have done things a little differently. This is going to come down to what they believe should actually be case precedent going forward based on case precedent past. That's all this is going to end up being. I just think it was just not clear. She just needed to provide clarity to everybody involved, all the parties involved, the defense team, Richard Allen. They all needed to be clearly stated that the hearing on the 19th was going to be to discuss the disqualification. It should have been a disqualification hearing. You want to review the timeline? Which timeline? You want to do which timeline? Because, God, there's so many. Rules, laws, and procedures. Yes. Do you think they're going to remove her? I don't know. RA telling his attorneys that he got a visit from the prosecutor and threatened to DQ his attorneys is how they found out, which is the only reason they initiated informal phone conferences. You think he got a visit from the prosecutor, or do you think they told him? Because I kind of took it like his attorneys relayed to him that during their phone conversation, McClelland requested for them to be disqualified. Can somebody disclose, or somebody depose Court TV and everybody that over a year ago said they had these documents? Yeah, why have a yeah, exactly. Yeah, you don't think so either. I keep going back and forth. It depends on the minute you ask me. But because of the lack of, if they were supposed to go through an interlocutory appeal, let me just say, like, this is my big question then. If they should have gone that direction, and legally that's the right thing they should have done, then why would the Supreme Court of Indiana allow this filing to be put on their docket? Why wouldn't they have denied it and said, no, you need to go through the appellate court? I said I'm ready to let this. I don't have a choice. We have to let it go. We have to let it go once they decide, unless for whatever reason, which I highly doubt will happen, unless they take it to, like, the next level, United States Supreme Court type of thing, which I don't see happening. I don't know. Maybe they will. I don't know. You've got people like Hennessy involved and Kara. These guys are pissed. They are pissed at what's happening because of the lack of following the judicial process. And then I guess we have to also understand, what can the Supreme Court rule? Like, what options do they have? Oh, the timeline of the October leaks? Well, I think it's bigger than that, to be honest with you. I think it's bigger than let me see if I can pull it up real quick. I think it's bigger than just the October leaks, if you want my honest opinion. When I was going back through, we'll finish this first. It was confidential. The judge said the phone conference. I thought that's what she said about. She said it was confidential, was the transcripts for the in-chambers hearing. But then the Supreme Court made her send them over anyway, whether she wanted to say they were confidential or not. I like Dago. He's just a good-hearted dude, and that's what I like. You have a new account and felt naked with no green? Well, welcome to the green. Bob and the judge emailed each other. Yeah. But that was about the transcript for the in-chambers hearing. I don't think anybody has actually asked for anything to do with the phone conference. Has that actually been requested? Maybe Bob said that and I missed it. It's very possible. I doubt the phone conference was even on record, though. I don't think. Yeah, I don't think we have a choice, Jen. I just don't. I think that we have no choice but to let it go. If there's no future filings or taking it to other courts, it is what it is. The Supreme Court is there to make the unbiased decision, and if what are we going to say? Like, the Supreme Court judge is also in the pocket of McClelland. I can't go there. I can't. You know what I mean? Like, it's just, that's too far. I'm not ready for all that. Woodhouse happened a long time ago, but Woodhouse put those YouTubes up and Nick was following those. He wasn't supposed to talk about settling with county. Yep. RA was blindsided by Nick McClelland or his office. I assumed he called BNR to ask what happened. Was he actually there, though? Jay Turner, I'm going to have to look into that, too. You're going to have to show me where that was. Because I thought that was his attorneys telling him that on the phone call, McClelland was trying to get them disqualified. When you totality one of Gold's words, Nick sees the Mark Cohen and Brandon Woodhouse, both we happening during his 17 days investigating. Okay, let me go back. Let me see if I can pull up what we're talking about. So I think that, yeah, once we hear from the Supreme Court, I feel like once these are set in stone, if the Supreme Court says she's staying, then and the new attorneys are staying, we just have to focus on going forward. I think that's the biggest thing. Of course, the prosecutor will want disqualified. That is not notice of disqualification. Exactly. Exactly. Bob said he emailed the judge. I believe that Sleuthy and Bob were emailing the judge and to get the transcripts of the in-chambers hearing. They were doing it together. So I don't know if we're talking about like who specifically sent the email. I think they were all CC'd on it. Okay, yeah, I don't think that's, yeah, no. I think they were all together on the email. I think we're talking, you guys are talking semantics. But I still think it had to do with the in-chambers hearing, but I don't, if he mentioned something about asking for transcripts of the phone conference, then that's different. But if he said that, I missed it. Okay, let's look at the leaks. But so I think that the thing with the leaks, I think you have to go back further, because what I'm noticing, Bob is Defense Diaries, Bob. Okay, so and I don't have all this in here yet, but I'm gonna add it. If you go back and you see how we were just talking about in this, we were talking about that they put that press release out on November 29th, and then Judge Gull immediately put in a gag order pending the hearing, and then during the hearing she solidified the gag order, right, which I believe was December 2nd. And if I have the wrong date, you guys can tell me. So December 2nd, the gag order comes into place, right? December 2nd, and then December 3rd, you have Chris Todd, who wrote the book about Ron Logan, was Forest for the Trees or whatever it's called. On December 3rd, Chris Todd goes on Court TV to discuss that he received crime scene photos. Now, we went back and we watched maybe I am? I'm not sure, Kyra. I might be. We went back and we watched this, and he talks about that he for sure had the clothing pictures on December 3rd, but he insinuates that he has more than that. He insinuates he has other pictures, like of the crime scene, because he says something along the lines of, well, we could go into, I can answer some more about the crime scene if you want me to. I don't know if we're going to do that here or not, Vinny. And Vinny's like, whatever, we're going to go for it. But then he never actually talks about the crime scene, but he does talk about like SA and things that had to do with the crime scene. Like he had seen pictures. He specifically says he saw the pictures of the clothes. Remember, they weren't out yet at this time. They weren't public yet at this time. They hadn't made it to anywhere, in the public yet. So that was the first we're hearing that those are out. And then in Discord, somebody who's now deleted talks about, and this is December 5th, talks about the fact that Abby had Libby's clothes on. So even if we go all the way back to when David Erskine was talking and his conversation got put public, he talks about that Abby was dressed and Libby was nude. So everybody essentially knew that part, but nobody knew that Abby was wearing Libby's clothes. But somebody back on December 5th of 2022 knew that They knew that Abby had Libby's clothes on. And he also, yes, I have a hypothesis. He states that he has what does he call them? Does he call them whistleblowers? I'm almost positive he actually uses the word whistleblowers. Well, let's not just take my word for it. I have the link in here so that we can watch it. So let's do that.
At that moment, and I do believe through the investigation.
Based upon the clothing that you saw.
Not show them today, and that's okay. But these are the articles of clothing that were found in the creek.
When you talk about articles of clothing, does this suggest that there may have been some sort of sexual aspect to what happened to these young girls based upon the clothing that you saw in these photos?
I can comment a lot more even about the actual murders themselves. We can wait for that if you'd like, through the Leo whistleblowers that we have.
There you have it. Through the LE whistleblowers that we have. Mind you, this is December 3rd. There's a gag order in place now, right? Because we're not going to try this in the media. He says it. Yep. The whistleblowers. Well, he befriended lots of different people in the case and manipulated, in my opinion, manipulated people into giving him information that they were privy to. Let me see if I can get out of this. So this is, for anybody who's not familiar with what I'm actually showing you guys right now, this is the presentation thing I've been working on. I've been adding to it every day. That's for you guys. I'll share it with you guys too, so in case you guys haven't already had it. And if there's anything in particular you feel like needs to be added to it, please let me know, because I have no problem adding different sections or getting any help from anybody who wants to help. But I'll pull up the link for you real quick. It's very interactive. I only do it on my computer, so I'm not sure exactly what it looks like on the phone. But it's accessible for all of you. Part of the reason I did it was for myself, to have some organization, and also for you guys, so that if when you go, wait a minute, where did I hear XYZ, or where did that come from? You know, like you can go back to it as well. It is not done. It is a work in progress, so take it for what you want. So that was so time-wise, when we're talking about like timeline of leaks, that was a big one to me. I was like realizing, like, as we talk about like the timing of this leak, because I keep going back to October 4th. October 4th is huge for this last leak, but hold on. You heard that Abby was wearing Libby's clothes years ago? Making friends on Discord. Aw, thank you. But I want this to, like I said, I want this to be with you, for you guys, so that it should by the time it's done, it should have anything and everything that you need, want, could use, could reference. So was the military guy who is no longer alive, which makes no sense, on the same base possibly that KK was taken to? I have questioned that and have never looked into it. So it's something I really probably should figure out. And it probably wouldn't even take very long, but I just haven't done it. Okay, so that's the first leak, the leak with the clothes. Well, it's not the first leak because there's so many different leaks, but this is the first one that I have in here. And then there's the thumb drive map. So The interesting part of this, and if you look at the timeline of leaks, the interesting part of this is he got this. There's some conflicting information on whether Brandon was sent this in December of 2022 or April of 2023. I think it was April. Other people keep telling me it was December. I don't think defense even had this in December. Maybe they did. According to the text messages between Mark and Brandon Woodhouse, he talks about it being in April. So I put either or. But this is the thumb drive map. I'm missing a screenshot. If anybody happens to have the 7th screenshot that I don't have, please feel free to email it to me. I'll add it to this. But so this has all the different ones. But the timing of this, when we talk about timing, August of 2023, Mark starts talking with Brandon Woodhouse. Now, in August of 2023, what was happening with the defense and law enforcement? Do you guys remember what was happening? Brandon did share it with Mark. That's what we have in the messages between them. Brandon was sending it to Mark. He sent it in chunks. Well, almost to the Franks. We were getting to the Franks. They were doing the depositions. So in August, they're doing the deposition. Yeah, the depositions from the defense team to law enforcement. And all of a sudden, now we have Mark, who ends up in Brandon Woodhouse's messages, trying to talk to him about what he got from, what information he has. Mind you, Brandon Woodhouse thought that Richard Allen was innocent. And Mark Robert thought that he was guilty. But he's in there telling him that he thinks he's innocent. And he's going to, quote unquote, share information with him in order to get this. So another interesting thing about that leak is that it comes up at the same time as the depositions where, according to the defense team, they say, hey, this is the first time we let on to law enforcement that we knew about the Odinism stuff. And it sucks because a lot of Brandon's videos are down that have to do with the timeline that I'd love to be able to put in here, but I don't have access to all the information anymore about like when he was arrested, when they came in and started, searching and doing things, and when they found out about that, like when the law enforcement found out that he had this whole thing. I don't have all the dates for that. I'm going to try to find it, but his search warrant was executed on 10/6 for Brandon. Okay. Well, that's good. That's interesting timing. Yeah, sworn statements under penalty of perjury. So we have that one. We have this big one right here. And then you have the next one. And all of this starts to surround the big thing about October 4th for me. So the F tree, which is, being put out there saying, we wanted to put it out there because we wanted to prove that Barbara McDonald was lying about what she saw on the F tree. And then, the Mark Robert friends come in and they're like, no, Robert was trying to put it on Facebook and he kept getting declined. And so he asked Mark to do it and Mark did it for him so that they could prove that Barbara McDonald was wrong. Now I'm thinking, okay, make sense because Barbara McDonald was on Court TV on September 19th. So what's the purpose on October 4th of making sure this goes up? That Robert is, even if that's true, that Robert is, continuing to try to post it and keeps getting declined. And then it's so important that it has to go on Facebook, that he gets Mark Robert to do it. And that Mark Robert's like, yes, it definitely needs to go out on October 4th. So guess what's happening on October 4th? Because it has nothing to do with this Barbara episode. That was weeks earlier. So that doesn't make sense. So then you go to the crime scene photos, because nobody gives two shits that the F tree's out, right? Everybody's like, yeah, whatever. That's not a big deal. Nobody cares. We can't post the crime scene photos. So what else can we do? What else can we do? So on October 2nd is when the defense had requested the deadline for discovery, and it was approved for November 1st. I don't have, like I said, this isn't done, so I have stuff to add to this part. Hi, venue. So then you have on the same day the Franks memorandum comes out, Mark just creates his GoFundMe just for non-nefarious reasons. October 2nd, the deadline. October 3rd, they put out the additional Franks notice, which is the one that they're putting out saying, hey, this is the other information, so on and so forth. October 4th, the defense tells the judge during a phone conference that they're ready to go to trial. She says, I think you guys are probably going to need an extension. You know, they're like, no, we're not getting an extension. We're ready to go. We're going January 1st. And then Rick Snee originally had said he received the photos the night of October 4th. He later, when he said he went back and double checked, he said it was the 5th. But once again, 4th, 5th, I'm okay. It's still right here, all at the same time as these big things are happening with the defense team. Defense says we're ready for trial. Oh no, we got to get some photos out there. Now, October 5th, early hours of October 5th, Murder Sheet gets the photos. They say at sunup they contacted law enforcement and the defense. We know they did not do that. October 5th, Snee and MS supposedly have a conversation, which is according to Rick Snee, which I have no reason to not believe. And then October 6th, which is Friday morning, he says that Rebecca Lynn Dunaway, who I don't have any idea who the hell that is, messages Snee. She runs a Facebook group apparently, but then there's other things that are, I don't know. That she messages Snee and says, hey, I hear you have crime scene photos. So he says then that night he realizes that it's out there now and somebody knows that he has the photos. So he posts on his community wall that he has the crime scene pics. I'm actually live at the time that this is happening, and somebody comes in and tells me about it. I remember. October 7th, I say Snee does the elephant live. It's called the Elephant in the Room, and he talks about the fact that he got the crime scene photos, that he had the conversation with Murder Sheet. He won't talk about whether Murder Sheet had them or not because he didn't want to throw them under the bus. Tells the public that he got an anonymous email, so on and so forth. And then October 7th, Holman contacts Snee. So I asked Rick on one of his lives if when he had this conversation with Murder Sheet, if they had mentioned to him that they had already contacted law enforcement. He said not that he could recall. But if he talked to them on October 5th night, they had already talked to law enforcement that morning. That's interesting to me. And so then we have, this is what I need to finish. So, because we have October 6th, Rosie says that he found out 1 hour prior at about 3 p.m. about the leak. Nick knew 24 hours prior, totally lines up with when Murder Sheet would have contacted them. And on October 8th is when the judge responds to Rosie. October 11th is when Robert unfortunately commits suicide. And October 12th is at 4 a.m. is when McLeland emails the others letting them know about Robert. And then October 12th, Gold says no more work on the case. So if you pay attention to the time where something is happening with the defense, something also happens with a leak. Every single time. And most of those leaks, they try to tie back to the defense. And sometimes they don't have to try. Sometimes it just is. But now I have some additional things that are happening in the background as I keep talking about this, because people have had conversations with Mark and are saying, wait a minute, this guy's had a lot of this information for a really long time. He didn't just get it. He didn't just get the pictures of a crime scene on October 4th and send them to people. This isn't new. He's actually had them and has told people about them for a long time, at least since September of 2022. Now, can I sit here and say that he absolutely has crime scene photos from then? No. But can I say that he has told people he does? Yes. But I can't say that he actually had them. Did he lie? You tell me. I have no idea. Yeah. Why would the prosecutor be investigating? That was another key. That's another thing I have to add in here. So he says that he was investigating it for 17 days prior to the 19th. Well, that puts us back to the 2nd. What? Wait. Why are we investigating a leak on the 2nd? How do you even know that there's a leak on the 2nd? That doesn't make any sense. Because guess what? There's no. So are you investigating a leak that it doesn't have anything to do with the defense? Now, I'll show you guys something else. That's why I said this isn't done, but it's available for you guys. I mean, there's a lot of stuff in here. There's working on the timeline for like every year with everything that happened on all the days, so on. I mean, it has everything. It will have anything and everything you can think of. It's got like the persons of interest. I haven't even added all of them yet. It's got those guys. It has like all their associates. Like you go in. I think I showed you guys this before, but if you go to like Brad Holder, you go into Brad Holder. It's got all of his people, all the people that go along with it. It's got the interviews they've done, and these are all like clickable. So it should be very easy to try to maneuver around. I said I don't do it on a phone, so I don't know how it looks on a phone or how easy it is on a phone. But this will all be filled with all the information of anything that anything we possibly can. And it's just got like the information on the girls, their parents. It's got a family tree if you're interested in that kind of stuff, like who's connected and how they're connected to each other. Yeah, he was constructing a leak on the 2nd. Oh, that's what I'm thinking. So, but let me show you something else. So if you remember when they were talking about, when we looked at the Mitch Westerman probable cause, do I still have that up? Or for his arrest, it talks about the type of pictures that Mitch Westerman took. And it talks about that they were side-by-side pictures. Okay, well, let me actually, speaking of Mitch Westerman, I should tell you guys, I think he actually bonded out today. When I pulled up his, my case, it says that his bond was actually received today. And he's also scheduled for his court hearing on December 7th at 9 a.m. Just an FYI. He's ordered to appear on December 7th. If anybody wanted an update on little Mitchie. He's like the project manager. He's like he's not the investigator. He's the project manager. Well, that's a great question, because they had a conversation where they told her they didn't want to try the case in the media. So they talk about that the pictures, let me see if I can find it real quick. There we go, side by side. He also stated there would have been side-by-side photographs which were previously used by defense teams in depositions. So they talk about that the pictures they found that Mitch Westerman took were side-by-side photos. Now, nobody has talked about a side-by-side photo. Nobody who's received the images have said that they were side-by-sides with anything else at all. And it doesn't clarify what pictures were actually taken. But I went through to see what side-by-sides could it have been, because they're talking about, that they had these side-by-sides out on the table for the depositions that were happening with law enforcement in August. Well, so there's the side-by-sides are actually Brad Holder's hand and the crime scene of Abby. The side-by-side of Holder's Facebook post and the crime scene of Libby. The side-by-side of sticks forming an F and the F in blood at a crime scene. then you have a whole bunch of side-by-sides where they're comparing Holder and Elvis's pictures. So the reason I bring this up is because there's supposedly 7 pictures, according to a lot of them. A lot of the people who received them. There's 7 pictures. There was supposedly 4 of the girls. There's 4 of the girls, and then there was the 2 additional sketches and the F tree. So just trying to put that in perspective of, okay, so here's the F tree. It's a side-by-side photo of sticks forming an F and the F. So somebody crops it. Obviously, because we're only getting the F. We're not getting a side-by-side photo of sticks and an F. We're just getting an F. Side-by-side photo of Holder and Abby, and a side-by-side of Holder's Facebook and Libby. Now, the Teresa Liebert sketch could have possibly been out because, as you remember, they were talking about that even they showed, it was either Liggett or Holman, or it was one of them, I don't remember which one they showed, and even that law enforcement agent had to say that, yes, they did resemble each other. I just don't remember what agent it was. So, but where do you see another sketch? Let's see. Let's see if there's another sketch. So Betsy Blair, sketch 2. Sarah Carbaugh, sketch 1. A sketch. Betsy Blair draws a sketch of the vehicle. And then the Teresa Liebert sketch. So where's the other sketch? They didn't even talk about it in here. So where did that come from? Why do they say, and when we, I could just say this for myself, when we look at the 2 sketches, they're not taken off of a table, right? And then they also said that the one of the girls, because now it's 4, but there's only 2. They only have 2. Let me see, actually. Let me see if they have antlers. If confidential photo from scene antlers. Because supposedly the picture, one of the 4 pictures is got the mouse on it. You can see the mouse, and it's supposedly on that picture of Abby. So that's interesting. I'm just trying to figure out, like, why would they have, where there's obviously more to these leaks, because not even all that information is actually even listed on what was being done for the depositions. And we don't have anything that's side by side. So I'm hoping that this investigation that law enforcement is supposedly doing is actually going to show, which I don't think it would, is going to show that these photos may not even be these photos that are being seen here. Does that make sense? Yeah, that you could see a mouse and it was a pic of a computer screen. Ooh, sniper. FYI, an extractor and ejector from 140 caliber P226 can be quickly installed in any other P226 and will function flawlessly. Ooh. That's still really good info, even if it is off topic. You know, I try to retain as much of the stuff that you teach me about guns as I can, even though I may not remember all of it. I do try to. I'm just not a gun person. So the originals were not blurred? I don't know. I've never heard that. When Snay, on his Elephant Live, he said that they had black bars across them. I haven't ever heard that. So why would they have black bars if they're just sitting side by side? So who added them? That's why I'm like, there's definitely things happening, because this is only 2 photos, maybe 3, but it still doesn't make sense that it's of a computer screen and not photos on a table. Like, we don't see any photos on a table, that he supposedly took photos laying on a table. Talk about Mike Thomas. I've always wondered about that, because his name does come up a lot. Coach Kev, is that who you brought up? F-Tree. I don't know if the photos have been out, but I've always heard a lot about Mike Thomas. But I do question, how would Mike Thomas have access to all of that info when they wouldn't even let him work on the case? I don't know, because we don't know their security protocols. That's confusing to me. Would Mike Thomas even be able to leak anything? The issue is that Nick McClellan knew about law enforcement leaks. The defense wasn't fully aware of the LEO leaks until after they were already removed. Right. Adding in that Barbara McDonald was holding on to the Purdue report while she was on court TV on September 19th. How the heck did she have the Purdue report on September 19th? Because in the September 18th filing, the defense didn't even have the Purdue report. They didn't get it until after. How convenient they all support defense's Odin theory. Verbal description in the Franks fell flat, so pictures are released to prove defense's point before trial. Oh, please, so transparent. So you think so? Because I could see that side of it. But then it's weird, though, because if you actually go through and you read Mark, which we started doing and we never finished. We need to probably do that at some point. All of Mark's comments from social media and all of Robert Fortson's comments from social media are actually very pro Richard Allen's guilt. So that puts me into, we don't know what Mitch thought. If I'm Mitch, I'd crop the photos to have no background at all. But you wouldn't keep them side by side, because that's what I'm trying, like this whole point, like to make it so that you can prove it. Why wouldn't you have the photos side by side still? Because that's kind of the whole point, is to show how much it looks the same. So if it is on the defense side, why wouldn't you want both out there? Because you want them next to each other for people to see how accurate it is. These are questions that I have. So now I'm not talking about anything with facts or anything like that. These are just questions that I have about the whole thing. Aside from an F-tree and a drawn diagram, there's many saying they understand the photo when, as far as known, they've not circulated too far. How is it seeming strange? Yeah, because I don't think that the crime scene pics, as far as I know, I don't think they've been widely distributed. I hear people, or I shouldn't say I hear, I see people comment that they were up on Reddit but removed, but I never saw them on Reddit, so I don't know. And there's also like the narrative that's out there of the people who were on this email leak were all very much that Richard Allen was innocent. And then I'm like, how does that make sense when the majority of people who got them don't actually think he's innocent? And I don't have anything against the people that got them. I've seen partial stuff. So like a couple of the creators have like zoomed in on different parts of things, but mostly like the grass and the surroundings. So and it is what it is. Nobody mass emailed me. I didn't get to be included in that. No, and even when Julie was like sending me the email where to show me that like they were sent via email, she cropped the top, so it's just got like a very top portion where you can tell that it is something, but it doesn't have anything on it. It doesn't. Like, that's not even in the screenshot. It's just enough where you know that that's what's there. So that's why I say, like, I have partials. I have a bunch of partials of stuff. So then this leads me to asking, so before when it very first started, when it very first came out and I asked the questions about the crime scene photos, I think I actually asked Snay, did they have markers, or did I ask Ruckus, or maybe I asked both. Did they have crime scene markers? Was there could you see anything where, were they taken at the daytime because the F tree looks like it was taken at nighttime, so on and so forth. And there was no evidence markers. And my first initial thought was that I went back to, could these potentially be from the perpetrator's phone? Well, if the perpetrator is Richard Allen, they have said under oath in their depositions that there is no electronic evidence that ties him to them. So then I'm like, okay, so either Richard Allen's not the guy, or there's no electronic evidence that ties him, right? So that means they're not from him. Now, could the perpetrator have used Libby's phone to take photos? Possibly. Is that possible? That's possible. Nobody's ever told us where these are from. We just know they're of the crime scene. We don't know who actually took them. What about the searchers? So we know the searchers took pictures of the clothes. Could the searchers have taken pictures of the bodies? Would that have been a thought that they would have had? I don't know, because I can't imagine that would be something you would think to do. But just because I can't imagine it doesn't mean that it's not accurate, right? So is that possible? And that's why there's no crime scene anything? Also, because I did study a lot of forensics, there's a process. So you have photos that are taken throughout the whole process of taking pieces of evidence off. You have to take a lot of photos. And if you guys aren't familiar, watch True Crime Web. He's very, very intelligent man. And he walks you through like how he would photograph and like how long it would take to photograph just a piece of evidence. And hold on, I got a cough. So could it be that that's just the initial photo they took upon the scene? Maybe. I don't know. That's all just speculation. T, your family is prior Elliot. Is there a standing ethics policy regarding crime scene responding officers and their personal cell phones? My dad and my uncle were cops, and my cousin's a cop currently. They can have their personal cell phones. Now, should they be taking photos like that? I can tell you that in a bigger city like LA, if you guys are familiar with what happened with like Kobe Bryant, there was a major lawsuit because law enforcement was taking, for our first responders and law enforcement were taking pictures of Kobe Bryant. And it became a very, very big deal. Now in smaller rural places, they will use their cell phones to take pictures. It's not uncommon. If you even think about like in like the Watts case, I'm just going to throw that out there because I have so much evidence from that case. Those guys were using their personal cell phones to take pictures of the people they were like interviewing, like witness like statements. They were taking pictures of their cell phones with their personal cell phones. So I think it's probably going to be more policies and procedures based on where they are. Grizzly said she was asked numerous times if she wanted them for money, and she said no. Did she show any screenshots that showed that? Because, I like to have a little bit more to it for money. And I hope that she actually would have given, if she was contacted, she would have contact info. Department issued phones on scene. No, typically your crime scene investigators are the ones who should be taking pictures anyway. But the problem is smaller departments don't necessarily have, like Liggett was like I think it was Liggett. Somebody will tell me if I'm wrong, but I'm almost positive it was Liggett was actually one of the only law enforcement there that was actually able to help process a scene. Like he was dual, and a lot of smaller places are like that. Defense mass emailed YouTubers in hopes they would release the photos to prove their Odin branch theory before trial. BM's diagram looked like a hot mess. I don't think that's true, because if you read the arrest affidavit of Mitch Westerman, it says that Mark Cohen is the one who mass emailed the YouTubers. So they say that he's the one who put it out on social media, and he mass emailed everybody. So I'm going to go with that for now until somebody can show me that that cop is not a reliable source. Libertarian, there was a reason they wanted those documents sealed, and I really don't understand why certain people that know it was BP that mentioned it to detectives are saying it's hogwash. I think if I could ask like the family a question, it would be something like that. What made them change their mind? If Becky Patty's the one that brought it up to Detective Purdy to look at Brad Holder, what made Becky Patty change her mind that it wasn't them? You know what I mean? Well, I would think that's what was my question. Is somebody along the lines definitely did. Either the defense did originally, and that's how the photo was taken from that Mitch took, or Mitch, or I mean anybody can add a black box. So I don't know. I'm just saying, like, that's a whole process down the way. That's why there's definitely somebody who's edited them, because they're saying in Mitch Westerman's affidavit, they're saying that he took pictures of side-by-side photos. Well, side-by-side photos are not what was sent to the mass public. So somebody from Mitch Westerman, who, when he sent them to Robert, or when Robert sent them to Mark, or when Mark sent them out to the mass public, somebody cropped them. Yes, they can be. They can be. But we'd have to know more about them. We'd have to know more about the process of what they did. Did the first responders take photos when they got there? Did the searchers take photos when they got there? Those are all questions I have. We have no idea the origin of these. We also can't even show for certain, we can presume or assume, whichever way you want to go about it, that these are the photos that are from these side-by-sides. But because we never had any hearings or anything along those lines, nobody ever proved to anybody what it was or where they came from. Are these photos that were already circulating, or are these a fresh set of photos? Hold on, honey. Hold on. Okay, let me see. Yeah, no, they didn't. So if personal phones are used, as technology moves along and cloud services capture everything, leaking photos is only going to get worse. Agreed. But like I said, I think it's different based on the type of, the city, how, who actually is there, what equipment they have access to. Hi, Shelly. And if not, then how can LE pros or defense be blamed for civilians posting, selling disturbing pics? Not to mention just the hacking abilities in general of people and being able to get access to things that they shouldn't have access to. Correct. He doesn't say that in the Franks motion. He says that actually to Murder Sheet. He says it to Murder Sheet, but they split it into two different statements. And I don't know if that's just because they chose to split the statement or if he gave two separate ones. But the first part, which is what made its way across social media, was that he does not believe that it was like any type of sacrifice, like human sacrifice or anything like that. I don't think, is Wisdom Sleuth here? I haven't seen Wisdom Sleuth. Oh, there they are. Wisdom Sleuth. Jen would like to know if you blocked her. Maybe you meant to block somebody else. Wisdom Sleuth. Yeah, they buried the second half of the statement. And so then, yeah, on the next podcast they talk about that he didn't think it was a human ritualistic sacrifice, but he does think that the persons of interest that they have did not or is still their persons of interest. They think it's him. Yeah, Holder, Elvis, and is it the three though? Because they kind of talk about Johnny Messer too. Like Johnny Messer, Brad Holder, Elvis Field, Patrick Westfall. Oh, I highlighted his comment. I don't know. I asked. We'll see. That's what I heard, and I heard from 3 or 4 different podcasters that they were emailed saying, for so much money, you can have these. If it was just one, I'd say, but 3 or more, I don't know. Maybe. But the question still comes to who is sending that? Who is sending that? Why wouldn't the defense use that opposed to Odinism? I think what they were trying to push wasn't necessarily Odinism. It was the oh my gosh, why can't I speak? Nordic paganistic part of it. And then the people who were involved practiced Odinism, so it became about Odinism because of that. But I think they were going more with like the Norse paganism part of it. Yeah, that's a great question. So is it all the same person who was trying to sell him? That'd be interesting to know, right? And what email was that? And they should have did somebody buy them? So here's the other really weird thing is that Robert guy was talking in Snae's comments, and I can't prove it was the same Robert, but I've never seen that Robert again, so I don't know. He was in there talking about that he had crime scene photos that he had got from the Yellow app and on the dark web. And he said he got them back in like April, May. That is why why Judge Gold couldn't take the chance of having an actual hearing or notifying the defense what was going on. The defense would have found the prior leaks and brought them up on, and they would have brought witnesses. They would have brought witnesses saying, hey, here, look, you want to talk about leaks? And everything I just talked to you guys about is all leaks that are post gag order. So the defense said in the Franks memo that they were struggling to know how to define Odinism with the context of the info they received from Ellie. Yeah. I think that they were like, it was like all encompassing. It's kind of how I read it. I know, right? They should be charged with having illegal crime scene photos. Wouldn't it be the same as if there is somebody who has them unredacted, maybe, but I don't know if it would be considered child P because they're deceased. I'm not really sure how that would go in. But I know from the first instance I ever even heard that they were out, the first person I heard they were out from said they were blocked, which then makes me think that they were blocked being sent from that person, and anybody before that was the one to put the blocks on them. And that could be anybody from the defense on. I don't know. Why would the defense do it? I don't know. Maybe because they knew they were printing them, and so they did it. Who knows? Maybe Mitch did it. Maybe Robert did it. I'm sure. I would assume that these people investigating this would know that. I heard another person, and I don't even remember who it was, that said that that Libby used to communicate with people through a Yellow app. I never really knew about a Yellow app, but so I've tried to like look at it, and it seems like it's more like a WhatsApp kind of thing where you can just message each other, but it doesn't save all your stuff. But then other people are telling me that, you use it, that it's like used for like nefarious things where you can send bad stuff. So I'm not sure. And KK was on the yellow app. If the leak was actually investigated, not the contract lead, but the minute they followed the money, the truth would be revealed. Yep. Not if they were unsolicited. Well, yeah, I mean, if you're paying for them, I think that you're going to have a whole nother issue. Hey, Skip. I think the ones that are accusing Mike Thomas of being involved must be doing it because they think they can connect him to the knot. I don't even know what the knot was. I literally am just like learning all this stuff. Like there's a group of people that are called the knot. I'm like, what? Mark said it was someone that Liggett promised a position. Yes, that's what he originally said. Yeah, and if you look at like Chris Todd says it's from LEO whistleblowers. Barbara McDonald says it's from her LE sources. There was a news segment that Carter went to France back in April of 2022, and that's when the Anthony Shots account expanded to the Ubo Yellow app. Yeah, so is it like over? I don't know. I don't know enough about it to have really an opinion on what it is. You guys probably know way more about it. And people bought them. And people bought them. Oh, Annie, oh goodness. And then the people who bought them sent them out. So this is another thing. So if this Robert guy had access to anything that was back from April, May, that he got from a nefarious place, are we even talking about the same photos? Are we talking about two different sets of crime scene photos? Because that's kind of where I'm at. All right, guys, I've been on for 3.5 hours. I am going to hop off and go hang out with my kiddos. I don't know. We just have to wait and see now. All the responses are in, so it's going to be, I guess we'll have to wait and see if Kara decides to do a response to the respondent's response like she did with the first writ, and possibly we'll get, see what she has to say about it. Otherwise, we're just going to have to wait for the Supreme Court. But I appreciate you guys. You guys always hang out with me for so long. It's crazy. But I will be back. I'll be back mañana. I don't know what we'll be talking about, but we'll be here. So thank you guys. I appreciate each and every one of you. I know that you guys have 1,000 other places you could go and hang out, and you choose to hang out with me. And just know that I appreciate each and every one of you so very much. Go enjoy the rest of your Monday.